Uh,
Yes.
May please your lordship, my lord, I beg to mention item number 33, my lord. This matter may kindly be fixed on 10th of June. I'll be filing the affidavit in reply, your lordship. I have taken the consent from the respondent, your lordship.
Item number
Item
33.
number, your lordship, item number 33, your lordship.
Both sides are represented. List on 10/6/2024 to enable the petitioner to file affidavit in replying the matter.
Okay.
May please, your lordship. Lordship, in item number 18, we have filed an additional affidavit to bring on record an annexure that has been left unannexed, lordship. So that may be allowed, lordship.
Obliged.
Please, your lordship, my lord, I beg to mention item number 30. I want to file affidavit in reply, may come after 2 weeks. I have taken the consent of earlier side. 30.
Both sides are represented. List after 2 weeks as to enable the petitioner to file affidavit in replying the matter.
May please, your lordship. I beg to mention item number 11. Lord, kindly adjourn for the day, my lord, due to personal problem of my senior, my lord. 11, my lord.
After,
2 weeks, my lord.
okay, both sides are represented. List after 2 weeks as paid for by land counsel for the petitioner.
That is, your lordship. In item number 25, the respondent number 3 has filed an affidavit in opposition. We need 1 week or 2 weeks time to file our reply in that matter.
Okay. They are private respondents.
Private, no, state respondent,
Okay.
respondent number 3.
Both sides are represented. List after
Can it be taken on 30th of May or
30.
30?
Okay. List on 30. No, 30 is Thursday. Make it 31st.
My lord, 30.
31/5.
My lord.
2024, so as to enable the petitioner to file affidavit in replying to the.
Obliged, my lord.
May please, lordship. I beg to mention item number 48, lordship, supplementary item, lordship.
48.
48, lordship. With the, I have taken consent from the other side, lordship. Kindly fixed after 2 weeks, lordship.
Okay. Both sides are represented. List after 2 weeks as paid for by land counsel for the petitioner.
Oh, may I plead your lordship, with the consent of the petitioner, I beg to mention item number 27. Lordship, in this matter, I require 1 or 2 weeks to file our affidavit, lordship.
I'm from the petitioner, ma'am.
Okay, both sides are represented. You are for respondent number 345.
345.
Okay. On the prayer made by the council for respondent numbers 3, 4, and 5. List after
2 weeks, 31st May.
2 weeks, so as to enable the petitioner to file affidavit in replying the matter. Any interim order is there?
No.
Okay.
Kindly date may be fixed, madam.
Make it 31st then. 31/5. Okay.
May I please, lordship? Lordship, I beg to mention item number 22 from today daily list. My senior Esovida is unwell, so kindly matter may be passed over for today.
Okay. Both sides are represented. Password for the day is paid for by land counsel for the petitioner. Okay.
Daily list item 1 for motion.
What is the date of the order?
Date of order is lordship 28/8/2023, lordship.
Okay. Mr. Arthur, counsel for the petitioner. Content. Notice that within 2 days, pendency shall not be a bar for the respondent. Comply with the order of the court. Give a date, returnable date after 5 weeks.
Obliged, lordship.
Item 2.
What is the date of the order?
9/5/23.
9/5
9/5.
is. Okay.
Within 3 months.
No, it's
the court
okay.
is
So
there.
that's why I remember. This is Kotogi and counsel for the petitioner. Same order. Date is
After 5 weeks. 28-6.
Yes, item 3.
Item 3.
May I please,
What is the date of order?
Lordship? And NXI page number 12, Lordship, date of order. Your Lordship, 25 of January 24, Lordship.
Okay. Mr. M. Saikia, counsel for the petitioner. Same order, same date, 28/6.
Idea of Lordship.
Item 4.
What is the date of the order? Date of the order,
Yes, madam. 31/1/23.
23. What is the time for compliance?
6 months.
Where is that?
Is 97 minutes. Last page, madam. Last page of the order is 97.
6 months. Okay. Mr. H.R. Ahmed, counsel for the petitioner. Petitioners. The same date, steps in 2 days.
Published.
Release shall not be by something. Release shall not be by.
Item 5.
May I please, Your Lordship? Look, the petitioners were initially appointed as ranger, my lord, during 1989-91. My lord, while they were in ranger post, my lord,
You said that they had adopted seal cover procedure for you. The stand of the respondents is that they have adopted seal cover procedure for you.
for us too. Because seal cover procedure, to adopt the seal cover procedure, my lord, three essential ingredients required, my lord. One is the officer must be under suspension. My lord, last time they submitted the instruction, vigilance, my lord.
No, just a moment. Somebody
Really?
last time made a mention that Mr. P. N. Goswami was out of station. Mr. Chakravarti, can you find out, Mr. P. N. Goswami Forest is not here.
We'll find out.
Where's the Forest? Just wait for some time. Last time somebody mentioned that
This item, my lord.
he was out of station, his father was ill. Somebody told us, right?
Of PN Goswami.
Just wait for some time.
Item 6.
Yes, you got information.
No, Manoj, I have not received any instruction.
Okay. Third Miss
D. Mohanta.
D. Mahathir and counsel to the petitioner. The petition projects that his superannuation is due on 31/7/2024. But the Departmental Promotion Committee meeting has not been held for the next higher post of Joint Director of Employment. And accordingly, this petition has been filed under Article 226 of the Constitution of India. Next. Mr. P.C. Subiya, an additional senior government advocate, accepts notice for on behalf of respondent numbers 1 to 4.
1 to 4, 1 not 4, 1 to 4 is my lord,
Director,
SP Das. His name is shown also. One, two, three, my lord.
this employment craftsman has a different sending also.
Yes, SP Das. SP Das.
Hmm.
Huh? What's the name?
I have received the instruction, madam.
সেইটো সুধিছো ক'ত গৈছিলা বুলি কয়? আৰে, অ, ঠিক আছে
Okay, 1 to 3, Mr. SP Das Leonard, standing counsel for respect.
2, 3 and 4, my lord.
মডেল
2, 3 and 4, you will be there. So, this is here for 1. SP Das Leonard, standing counsel for
এইকেইটা ভাই বিয়ে হোৱা নাই
Directorate of Employment, Employment and Craftsmanship Training. Accepts notice on behalf of respondent numbers 2, 3 and 4. Next paragraph. Pursuant to next paragraph. Pursuant to order of this court dated 1/5/2024.
Yes. This was good.
The learned standing counsel for respondent numbers 2, 3 and 4 has produced a written instructions dated 9/5/2024 received by him that the promotional process for the post of Joint Director of Employment will be held as soon as possible after model code of conduct period is over, if all conditions are met. So the said instructions are made a part of the court.
Matter may be disposed of, my lord.
No,
Matter may be disposed
no,
of
because
because
there, you see, like,
they have, my lord,
no, you see, what they have done is, they have added a tail to the letter. The letter is that everything, if all conditions are met. So conditions we don't know, it may be very hot summer, there will not be condition met.
But
For
ACS
the
are
meeting.
fall, my lord. ACS.
Yes,
No, no,
3
that
years.
is okay, but you see, this is a condition. Conditions are met, maybe very hot, you can't have a meeting.
Oh, yes.
Rain, you can't come to office, can't have a meeting. So conditions are very difficult. No?
Yes, yes, yes. 1:4, they will have to consider.
No, not only that. High temperature, you can't go and attend meeting,
Yes, yes.
so they'll have to wait till winter. Will not.
Yes, yes, my lord, understood.
Yeah.
Like the issue is,
Issue notice returnable in 4 weeks. Requisite extra copies of the petition is served on the learned senior government advocate as well as the learned standing counsel for respondent numbers 2, 3 and 4.
One
of
item.
the day. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 5 to 8 by registered post with AD. Next, learned counsel for the petitioner is that the shall collect the postal receipt number and submit postal track report prior to the next date of listing. Next, para the pendency of this representation shall not be a bar for the respondent authorities to initiate the constitute the Bhattan Promotion Committee and to initiate the promotional process for the post of Joint Director of Employment. Next, list after 4 weeks.
I'm retiring on 31/7/2024, my lord.
You've taken
So
note
there
of
has to be some time limit fixed because otherwise they'll, Lordship will kindly appreciate January 23, this post surface. And till date, they are sitting over the matter. Rule says, my lord, they have
No,
to
no,
do it
you see,
prior to surfacing of the
We
vacancy.
can't compel them at the motion stage.
My lord,
We
I'm not,
give them
I'm
notice.
saying that a fixed time limit for, because if they go beyond 31/7, my lord, I'm a loser, my lord. My right to consideration is violated.
No,
forget about-
even post retirement, you can always be considered, give a notional.
maybe or
benefit.
may not be
That
considered.
is something we always do. But you see, you have come in the fag end.
Fag end in them, I've submitted
can't-
representation, my lord. They set over my representation.
It's okay, we can't do anything more. At this motion stage, we will not.
Bless
do
you.
anything.
At least time limit, my lord, within a month, because
They
they can
have committed themselves, they will do it after the model code of
expeditiously.
conduct.
That my lord will incorporate at least.
You have not heard me.
I'm
If you
sorry.
don't, if you not
I
heard me,
beg
please
your-
don't
Lord,
repeat.
I beg apology.
It's okay.
I beg apology.
time being item 5.
Yes, Mr. Gogol, we are issuing a notice then,
My lord, notice.
because Mr. Kodaki presses that the
No, we
ingredients of the seal cover is not pending because
I had placed
his charge sheet
instructions,
has
my
not
lord.
been issued, nor any prosecution criminal charge has been framed.
My lord, the instruction I had placed, it is also with me, my lord. The
Instruction-
regional department
Nothing
said, my
can
lord,
dispose of on the basis of instruction itself.
no, my lord, the language is different, my lord. Here is a pending regular inquiry that used.
Yes, my lord.
But in the case it relies upon its, my lords, it's a preliminary inquiry.
Look,
This,
I'll place it another regular inquiry order, my lord.
but, my
Janki
lord,
Raman,
I understand, my lord. Let me have some notice, let it come formally, my lord.
Yes, sir.
Otherwise I will be in trouble.
Look, last 3 months, my lord, since February, I done instructions, they could have
Notice.
said on that day, last time affidavit was granted 2 weeks time to file affidavit, my lord.
it's okay. See,
Therefore,
no, Mr. Kodaki, every honorable judge has his own view. Correct.
my lord, absolutely.
If there is a binding precedent, I am bound by it. But what happens is that in motion matters,
Look,
why I personally don't issue this kind of requirement of giving us instructions, because otherwise there is a delay.
That's the thing, my lord, since 6/3, I am here. 6/3
that's okay.
onward, my lord, I done instruction.
No, that's
Because
why.
earlier also, I have two judgment of this honorable court on instruction in the similar fact, my lord. Ditto facts, dispose of.
No, I understand, but that's why I'm
In
issuing
in
notice.
case of chief engineer in PWD, and one is same case, promotion from ACF to deputy commissioner, conservator forest.
Okay.
On instruction, both cases were disposed of, allowing the repetition on the ground.
Without notice, I have very
I
bad
mean,
experience.
I accept it. No, that's why we have some problem.
I have an immensely bad experience in disposal of.
You know, can I say something, not because your lordship, if your lordship wants to know, if your lordship, because they got lot of time. Since 2000 March, my lord, let it be taken up, notice issued may be taken up next week, my lord. It will go for admission again. That will create problem for us.
Well, Mr. S. Kotage and counsel for the petitioners, as well as Mr. D. Goel and as standing counsel for the forest department. The case of the petitioner is that the recommendation of the DPC in respect of the petitioner has been kept in seal cover procedure. It is projected that the same is in violation of the law well settled in cases where seal cover procedure is required to be adopted. Accordingly, alleging depriving of promotion, the present petition has been filed under Article 226 of the Constitution of India. Next paragraph. Although notice of motion was not issued in this matter, but this matter was adjourned on 6/3/2024, 4/4/2024, 8/4/2024, and 24/4/2024, so as to enable the respondents to produce instructions or to file affidavit. In this regard, the learned standing counsel for the forest department has produced a copy of instructions dated,
29/4.
what is it?
29/4, my lords, digital sign. 29/4.
No, it is not 29, it is 4/4. Dated 4/4/2024,
Comes to 29.
Hmm?
Since
Four,
we're
four.
29,
This is
four.
4/4, it's
Four,
not
four.
29. 4/4/2024. Wherein, whereby the standing council is instructed that the selection committee in its meeting held on 14/11/2023 had decided to adopt seal cover procedure for the petitioner, pending regular inquiry as per vigilance report. And a vacancy is kept for him in the roster register. First off. Be that as it may, you should notice a motion returnable on 29/5/2024. You have received extra copies?
Yes, sir.
Well, there is. And then send also.
Yeah, please. Extra copies of the petition is already been served. No further steps is required to be taken in respect of the respondents. Any private respondents are there?
No, Milord.
Based on 29/5/2024. We make an individual dispose of.
Violations.
And endeavor shall be made to dispose.
I'm not sitting it, but if I'm there, you can always press. When is your retirement due?
After 2 years.
Before that, the instruction for this is made a part of the contract.
Violation.
Mr. Kotoki, I have very bad experience. On disposal at the motion stage.
Item 7.
Problem that earlier 2 case, that was
That
done by
much okay,
other
but there's
court.
I have got a
That's the problem for us also because we have to face the.
I have very bad experience. Yes.
Meet leader. This is
Second.
pertains to appointment compassionate ground also. It's a covered case.
2010, we are not entertaining.
No, it's a covered case also. Yeah.
No, first, what is covered?
Next number 7.
How many judgment?
No,
An
how
example.
it is covered? Then less than 3 years service.
Yes, sir.
So that has been the order passed by this honorable Singh Gurjar, that has been appealed by the government. And that is the state by the division bench.
Which page?
Page number.
Page 30, Lordship Policy, page 30, rejection. Serial number 55. Tapas Kumar Pal, so and so, balance of service rejected as per OM, the balance of the service of the so and so is 2 years, 7 months only, and 3 years, 3 months, 3 days. So less than 3 years, my lord, that has been the office memorandum says 1/6/2015. If it is a less than 3 years service in his, my lord, then my lord, compassionate appointment is not eligible. The principle is that my lord, less than 3 years means the person is going to be retired. So retired person, sons.
No, but that has been set aside by this court.
Yes, Lord.
Yeah,
1646
which one?
21.
We appeal to?
Appeal to now.
No, we have the appeal, my lord. Against the honorable single judge. Justice Devashish Burwar's orders against, we have appealed, that order has been stayed.
State. Oh,
Division bench. That's why holding the field, the office memorandum, my lord.
just a minute. Sir, you have still your case to be dismissed for a different reason. You see, what had happened was your father died in harness in 2010.
10.
Your application was taken up and rejected by the DLC in 2012.
Lordship, SLC rejected in 2022, Lordship.
No, in
SLC
2012.
rejected 2022, Lordship.
No. 2012. What had happened? What was the decision of DLC? It was rejected.
No, Lordship. SLC rejected. Lordship. DLC not rejected.
Or DLC did not.
Yes. SLC rejected in
It
2020.
recommended.
Yes. Lordship.
Where is the DLC resolution?
See, Page number 21. Lordship.
21.
21. Serial number 2, Tapas Kumar Paul. AB Constable.
This is not a DLC, my lord.
So then you see,
No, it is here my department has forwarded it to the additional director. It is not a DLC, my lord, recommendation.
no, but DLC must have allowed it. That is
Yes,
why
sir.
it came to SLC.
Definitely.
Otherwise, it would not have come. But
By-
2012 application,
Well, application after 1 year, well, it is not.
13.
two principles operate against you. That is principle 10 of the OM of 15. And second is that Supreme Court judgment of what is the name? State of West Bengal.
Yes, Lordship. But that
Some Tiwari.
particular has been
Developed.
hit, our case also. Debabrata.
Ah.
This is not hit our case, Lordship.
Why?
And in paragraph 6, last part, Lordship, 16.5. There was no,
15.5.
yes, Lordship.
Yes.
There was no policy in West Bengal, Lordship, but we have policy, Lordship.
Hmm?
In West Bengal, there is no policy to govern.
No. Para 7.4 and 7.5. Even if there is a delay on part of the state respondents, then also your case cannot be considered.
Lordship, the thing is that before stay of the in appeal, Lordship, we have filed one WPC, Lordship. We have filed
Where is that?
an additional affidavit, Lordship.
Additional affidavit.
Yes, I filed one additional affidavit.
Page
106. Lordship. With liberty, we have withdrawn that. Lordship.
No. You see, Mr. Adhyapa, this doesn't help you. This can only give you, what do you call, this can only protect the present reputation.
Yes,
But the fact is that we are dealing with a case of 2010, for which recommendation was made in 2012. We are, even from the date of recommendation, we are 11 years past.
Thereafter, Lordship, in 2022, the SLC rejected our proposal, Lordship. And against that proposal, we filed this application.
You file,
This petition, Lordship.
no, we still can't entertain. 2010, we can't entertain. What Mr.
And
Hassan-
Article 1 of the OM.
This is squarely covered by the West Bengal versus Development Doctor. And also scheme also says, my lord, scheme is strictly has to be complied with the my lord, terms and conditions of the application applicant. And 2015, my lord, notification, as per notification that has been rejected by the SLC. Only one ground, but there may be another ground. It is the first ground,
No, but we'll impose some cost on the state this time.
my lord.
We'll impose a cost on the state.
No, my lord.
You see, in the judgment of this court in that Achyut Ranjan Das, the direction was to convene a meeting regularly.
Yes.
That is true, my lord, that is not.
So now you see somebody applies for a
2000
compassionate ground in 2010. Recommendation is made in 2012. And SLC takes up the matter in 2023, after 11 years,
22.
22, so after 10 years. For that 10 years, he'll have to give some compensation.
There may be something, my lord, some communication maybe in between them, I don't know,
But state will pay him compensation
without any information.
with liberty to the state to recover it from those people who are responsible for delay.
In fact, my lord, after passing of this honorable court's order, my lord, the chief secretary has issued notification also. You regularly hold the
No, so
meeting.
therefore you recover it. State will pay and recover it from those officers who have not complied with this case, because this can't be, it shocks the conscience of the court. Recommendation of 2012, the SLC doesn't take up. It's shocking to the conscience of the court.
For example, there is needed to be an order to be passed, my lord, that is
I
true.
understand there may be hundreds of causes.
Yes.
One of the causes is that paperweight did not come along with the along with this application. So therefore, the application flew away.
But
may happen.
but in this case, my lord, he has complied with, my lord, this terms and condition of this.
After 10 years, if you do it, I tell you, it's shocking to the conscience of the court. We are granting a 5 lakh rupees compensation. Let it be recovered from the officer to cause the delay. And let this order go to the chief secretary so that he will pass an order compelling all the pending applications to be taken up.
So in this case, that notice be issued, my lord, I will obtain instruction of why it is delayed.
No,
2010
it's not
matter.
required. We accept your submission that there is a delay. There are causes. We'll take it. Since we are dismissing it, we'll take from you that you have made an explanation, but still the state has to pay cost. You can't go away.
So sir, in this regard, other two.
If there are inefficient officers, sack them. Terminate their service, drop disciplinary proceeding and take away their service.
And Lordship, this petitioner is similarly situated. This.
We are not, 2010, we are not entertaining.
21, Lordship.
We are not entertaining.
No, no.
Heard Mr. Action Adhyapak and counsel for the petitioner.
And Lordship, another is 2027 SCC, there's a decision, Lordship. The 2027 SCC 617, Lordship.
20.
2027 SCC 617.
Yes, sir. কি কৈছে কেছটো? সেইটো দিলে নহয়, 3 বছৰ চাকৰি কম টকাৰ কাৰণে ৰিজেক্ট কৰিছে। Similarly situated facts and
Yes, which paragraph?
Paragraph, Lordship, maybe 11.
Yes. How does it start? Okay. Based on the and counsel for the petitioner, as well as Mr. T.C. Shutir and additional senior government advocate appearing for the respondents. Next, one. The case of the petitioner is that his father, late Kajal Mohan Paul, PAUL, had died in harness on 27/2010. Stop. Without any delay, the petitioner had applied for appointment on compassionate ground on 7/6/2011. Full stop. The district level committee from Hailakandi district in its meeting held on 30/11/2012 recommended the name of the petitioner for appointment on compassionate ground. As per the procedure prescribed, the DLC recommendation was taken up for consideration by the state level committee after more than 9 years on 10/2/2022. And the proposal was rejected on the ground that the deceased had a service period of less than 3 years. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner had earlier approached this court by filing a writ petition, which was registered as WPC 6424 of 2023. But due to certain reasons, the writ petition was allowed to be withdrawn with liberty to approach again by order dated 3/4/2024. Next, it is also submitted that clause 1 of the office memorandum dated 1/6/2015, which provided for, which excluded consideration of appointment on compassionate ground if the deceased person had less than 3 years of service, was struck down by this court by order dated 30 January 2023, passed in WBC 1646 of 2021. In this regard, the learned additional senior government advocate has submitted that against the said judgment dated 30/1/2023, passed in WBC 1646 of 2021, a writ appeal has been filed and the said order has been stayed. Next one. In support of this writ petition, the learned counsel for the petitioner has placed reliance on the case of NC Santosh, SCNTHOSH, versus State of Karnataka and others, within bracket 2020, bracket code 7 SCC 617. Next paragraph. Per contract, the learned additional senior government advocate has placed reliance in the case of State of West Bengal versus, what is the name?
West Bengal,
What is the name of the parties?
West Bengal.
State of West Bengal versus Debabrata Tiwari.
Devabrata Tiwari.
আচ্ছা আচ্ছা মনে আছে
I think it's there, right? Because even if the state has caused the delay, the delay itself will disentitle consideration of appointment on compassionate ground. Next paragraph. In the present case in hand, comma, it cannot be said that the application of the petitioner was petitioner submitted on 7/6/2011 was within a period of 1 year from the date of death of his father. Full stop. The district level committee from Hailakandi district had also made their recommendation on 30/11/2012. Next one. Next, continue. However, the state level committee, an authority which is mandatorily required to take up for consideration the applications forwarded by the district level committees and give its approval for the appointment of persons on compassionate ground. Took up the application of the petitioner in its meeting held on 10/2/2022 at 10:30 AM in the conference hall of the Chief Secretary, Assam. In the minutes of the meeting of the 14th state level committee pertaining to Home and Political Department for appointment on compassionate ground, which is annexed to this writ petition as Annexure 5, there's no explanation as to why the DLC recommendation made on 30/11/2012 was taken up for consideration after more than 9 years, 3 months. 9 years, 3 months. On 10/2/2022. Next paragraph. This court in the case of Achyut Ranjan Das versus State of Assam, 2006 within bracket 4, bracket close GLT 674, which was decided on 38,006. Comma. The principles governing the compassionate appointment and well, was laid down by directing that henceforth claims relating to compassionate appointment will have to be considered on those parameters. First one. The relevant principles, principal numbers two to 9, 2 to 10 are reiterated below. Next paragraph. This is Roman 2, no? Roman 2 to Roman 9, Roman 10. Next, from the above principles as laid down in the case of Achyut Ranjan Das within bracket Supra. Or the district level committee was directed to meet once every 2 months on the last Saturday of the second month. And the state level committee was directed to meet once every 3 months. With a further direction that all vacancies available under the quota of compassionate appointment must be filled up within a period of 6 months from the date of occurrence of the vacancy in accordance with the directions. Next paragraph. The next paragraph. We may mention that the law laid down in the case of Achyut Ranjan Das within bracket Supra has remained undisturbed and is being continuously followed till date. Next one, therefore, comma, the non-adherence of the state level committee to hold its meeting on time as mandated by the decision of this court in Achyut Ranjan Das within bracket Supra has shocked the conscience of the court as to the inordinate delay of 9 years, 3 months in taking up the 9 years, 3 months on part of the SLC to take up the DLC recommendation made on 30/11/2012. Next paragraph. In the present case in hand, the in support of the case of the petitioner, the land counsel for the petitioner have referred to the case of NC Santosh within bracket Supra with the reliance on paragraph 11 thereof. You're sure you're relying on paragraph 11? 11 is something else. It doesn't make sense in your case. Last part.
Yes, sir.
Most of in the considered opinion of the court, comma, the case of NC Santosh within Vedi Supra does not help the petitioner in any manner. Full stop. Because of the fact that the application of the petitioner was considered by the DLC and recommended, and his name was recommended by minutes of the meeting held on 30/11/2012. Full stop. It is in view of the inordinate delay in the final decision by the DLC, by the SLC, comma, a situation has come up whereby even the delay on part of the state to finally take a decision in the SLC has disentitled the petitioner for a consideration for compassionate appointment in view of the decision of the Supreme Court of India in the case of State of West Bengal versus Devabrata Tiwari. Just for paragraph 7.4 and paragraph 7.5, the said judgment is quoted below. Next, but from the above, it is clear that that after considering all the aspects of the matter, the Supreme Court of India has also opined that even delay on part of the respondent authorities in disposal of the application for compassionate appointment would disentitle such an application for a consideration, as the immediacy of appointment is lost. Full stop. Next, moreover, comma. In the case of NC Santosh within bracket Supra, it has been held that the policy in force at the time of consideration would govern the application for compassionate appointment. Full stop. Therefore, at the present juncture, in view of the pending application of the petitioner, comma, the OM dated 1/6/2015 would be applicable in the case of the petitioner. However, under principle 10, numerical 10 of the said office memorandum, it is provided that if the application of the eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application, would require no further consideration and must be understood to have spent their force. Full stop. Moreover, comma. In view of the judgment rendered in the case of the ratio laid down in the case of Devavrata Tiwari within Packet Supra. The court is of the considerable opinion that the delay self disentitled the petitioner to consideration for the competent and compassionate ground. Next paragraph. This court had spoke upon consideration of the inordinate delay has already held that the delay on part of the SLC to take up the DLC recommendation of the petitioner on compassionate ground within time prescribed by the law laid down by this court in the case of Achyut Ranjan Das within Packet Supra has shocked the conscience of the court. First of, in view of that, the court finds that the petitioner would be entitled to a common law remedy of monetary compensation for delay on part of the state level committee to take up the DLC recommendation made on 30/11/2012 within the time prescribed in the case of Achyut Ranjan Das within Packet Supra. Full stop. We accordingly find the petitioner entitled to a compensation of ₹5 lakh, which shall be paid by the state to the petitioner within an outer limit of 2 months from the date of receipt of a certified copy of the order in the office of the Chief Secretary to the Government of Assam. Full stop. However, the state is granted liberty to recover such amount from any of those persons who are found responsible, who are found after an inquiry that they are responsible in the delay. Next paragraph. Having noted that the present case has been taken up after 9 years, 2 months from the date of DLC recommendation, comma, the Chief Secretary to the Government of Assam, being the head of the SLC, is directed to do whatever is required so as to ensure that all pending DLC recommendations are placed before the SLC within a month from the date of receipt of a certified copy of the order, and in all event, SLC shall mandatorily be held within a period of 2 months from the date of receipt of a certified copy of this order, i.e. 1 month. So now this is stop.
Two months.
2 months from the date of receipt. 1 month they will make inquiry, get all
Because
the.
code of conduct is going on, but not still.
No, they can always recommend and postpone it. You know,
2 months.
public employment is something which is not stopped by the model code of conduct. You have seen that model code.
No, that is to, they are busy, otherwise.
No, no, that's okay. That's okay.
Anyhow, to be honest.
They will do it. Next paragraph. The petitioner, while forwarding the certified copy of this order to the office of the Chief Secretary, Government of Assam, shall provide his email and or WhatsApp mobile number to which he shall be communicated. Shall be to which communication may be made by the office of the chief secretary to the petitioner. To stop. With observations and directions as contained above, this division stands dismissed.
Obliged, my lord.
All right, six.
Uh, Item 6. Item 6.
Item 8.
Yes, you filed an affidavit?
My lord, I have filed that.
Yes.
At paragraph 2, my lord.
Okay. This is
Page number. 90. 90.
called by the earlier order
Page 90.
at page 80. For Mr. S.K. Roy, non-counsel for the petitioner. For government, for the government, Mr. ATC Chudiar and additional senior government advocate for respondent number 1, who is for personal department. You're the 1 and 2. Okay, so D.O. Commonweal Leonard standing counsel for the health department appearing for respondent number 3. RM Bora Leonard standing
RM Bora for respondent 5, your lordship.
for respondent number
5.
5. Who is for 4? Social. You're there.
Miss A. Lodha. Miss A. Lodha.
A. Lodha Leonard standing counsel for respondent number 4. And Ms. Bora will be 5. RM Bora standing counsel for respondent number 5. Next paragraph. The 27 petitioners herein who are suffering from various disability which are more fully referred in paragraph 2 of the additional affidavit filed on 9/5/2024. Project that they have offered their candidature for being employed in class 4 posts pursuant to advertisement dated 25/3/2022. And they had qualified on merit on 4/5/2023. And their names have been recommended by the SLRC to their respective class 4 posts on the different departments on 9/5/2023. However, the appointments have not been made till date. And it is projected that the merit list would expire on 8/5/2024. So same thing has happened. Here also the only relief you are asking for is the extension of
Extension of the merit list.
merit list. But
Yes.
you're not asking for employment.
Okay.
So this repetition can't be allowed. We'll have to dismiss
My
it.
lord,
You see, your only prayer is to extend the merit list.
yes,
That can't be done. Only that relief can't be given when you're not asking for any other prayer.
my lord, the honorable Girish Alkar direct to provide us the medical report and the decision. Like that has been, some petitioner have not received, my lord, and some.
No, we are not on that. You see, what is the relief asked for? Relief asked for is for extension of merit list.
Yes,
That itself only, there's the only prayer. We can't grant that relief. That is what has happened in the earlier case also.
my lord, the similar prayer, my lord, 86 similar order, my lord.
No. You see, what is the principle of a writ petition? You must seek something for yourself. What is the relief you are seeking for yourself?
Sometime, my lord, because the petitioner can approach this honorable
no.
court, my lord, because if they approach, my lord, this honorable court, then, my lord, sometime may be given, my lord, they.
That can't happen. Only a select list cannot be extended when you're not asking for any other relief. You're not asking for a direction to be appointed. And that prayer is not there.
Because, my
Only-
lord, the liberty has been given to challenge the medical report, my lord. That, my lord,
That you could have challenged and asked for an extension of the extension. We can't extend the period to enable you to file another writ petition.
Yes.
because, my lord, in earlier writ
We
petition
don't
has
know,
been filed.
we're not, you see, principle of, you see, what is the
Final
principle
writ.
of a writ? You must ask for any relief for yourself. What is the relief you are asking for yourself? You are asking for a relief of extension of the merit list, which will affect others also. There will be extension for others also. And if you see, once the court has extended the merit list in another case, you are covered by it. You don't need an order for yourself.
No, there is separate list, my
So
lord.
we don't know. We are asking you a question, you give a response to it.
My lord, that is the advantage, same
There-
disability
there-
exercise, my lord.
There
but the
cannot be an
advantage-
extension of the merit list to enable you to file another writ petition.
Here is the main pair and the pair is same pair.
Only prayer.
Only one pair.
Otherwise, if, my lord, they will come, my lord. In the meantime, my lord, the merit list will be expired, my lord. Then also, my lord,
No, there are so many things which may happen.
yes, my lord.
For everything, we will not entertain a writ petition. There are so many things which may happen. Floods are coming within 3 months. So can we have a presumptive writ filed for everything? Somebody may be driving in a very high speed in MG Road, High Court is there. While crossing it may cause an accident. So many things which may happen. This
For-
writ can't be entertained.
my lord, 4 weeks time. my lord. Sometime, my lord. That I mean,
Okay. The only prayer in this writ petition is to extend the merit list. With no other primary or any consequential relief sought for. Full stop. Therefore, as the petitioner is not seeking any relief for himself. Or the question, the issue of maintainability of the petition is required to be examined. Next, but according to the General Counsel, the petitioner placed for some time to address the court. This after
3 weeks.
this after 3
4
weeks. You see, that day we pointed out to you that this is a defect for which after passing an order, we had to, I could not sign the order. That's something I told you.
That is grade 3, madam.
No, whatever the grade 3 and grade 4 is
Same.
principally same. We told you, and then still again this rate petition has come up. We told you that we have, we passed an order on the open court, but when I am signing it, I read it again and I found that the prayer, no consequent prayer was there. And we informed you that you could not sign it. The matter was district thereafter, but you were absent. So you are aware of this fact, and again this rate petition has come. You see, these makes things simpler for me.
And
Correct.
madam,
Once you make simpler, I don't have to read the file and then anything can pass by.
yes, here all.
But if you don't make things simpler to me, if I start reading, then you have to take what comes. Correct?
But in grade 3, my lord.
No.
I have only.
Item 9.
I come from a place where order 2, rule 2 and order 3, rule 1, they are, I mean, that's a basic the fundamentals we have done very hard way.
May I please? Also, we are led by Civil Council Kane Suri. Also, pass over the matter for time being.
For time being.
Yes.
Okay. Then
Item 10.
Can be better if possible for a time limit.
just a moment. After some time.
Item 12.
None appears on call for the petitioner. This for your vote?
Appearing on behalf of respondent 5 AG Lordship, on behalf of Mr. B Sharma.
Okay, who is for Industries Department?
Mr. A Kalita,
Mr. A. Kalita. Mr. A. Kalita, standing also for the Industries Department. Representing respondent was 1 to 4. You have a 5.
yes,
Yes,
D Mohanto,
D. Mohanta,
on
Leonard,
behalf of Mr. B
counsel
Sharma,
appearing on behalf of
Mr. B Sharma,
Mr. B. Sharma, standing counsel for respondent of 5.
AG.
Treasury's finance will be appearing. Finance. No, who is there for finance? Mr. B. Gogay, standing counsel for finance, representing respondent number 6 and 7. Next person. The petitioner claims that despite 28 years of service, he has not been promoted. And according to this, petition has been filed under Article 226 of the Constitution. Issue notice returnable in 4 weeks. Requisite extra copies of the requisition be served on the learned state and departmental council in course of the day. Next, the petitioner shall take steps for service of notice on respondent number 8 by registered post with AD. Next, pendency of the requisition shall not be barred for the respondent authorities to address the demands of the petitioner. One more thing. Deficit about promotion. This will make a full stop. The petitioner has assailed the promotion given to respondent number 8 on the ground that the promotion was made ignoring the seniority cum merit service rule. Accordingly, this petition has been filed. You are there?
Yes, Lordship. M. Deca.
And they come, we have for the petitioner. Let's talk for 2 weeks.
Quickly, your place.
4 weeks.
Time being item 10.
I'm sorry, my lord, I was in
It's okay.
support number 1, right?
You are issuing a notice.
My lord,
Any appointment made will be subject to further orders of the court.
my lord, one post may be, my lord, total, my lord, advertised post was 10. And select list has been prepared finally for the 9. One post may be directed to be kept vacant in the meantime. My Lordship may kindly see total advertised post at page 26 was 10. And in the final shortlisted candidate, 9 my lord, that has been selected. Page 39.
Only 9 has been selected.
Yes, ma'am.
Once. But Mr. D.K. Sharma, counsel for the petitioner. As well as who is any CGC present? No. Okay. And Mr.
Presented.
Mr. SP. So this is CEC appearing for the respondent number one. The case of the petitioner is that he had participated in the selection process of NTPC Limited within bracket respondent number two pursuant to advertisement dated 23/8/2023 for the post of electrician.
Artisan electrician,
Huh?
artisan electrician,
What is the name?
artisan, ARTISAN,
Artisan electrician.
electrician.
Artisan electrician. This one. It is projected that having qualified in the written test, his name was shortlisted for skill test. And it is alleged that the skill test was not conducted. And in this regard, certain anomalies perceived by the petitioner has been narrated. However, in the result declared on 12/4/2024, the petitioner was not found selected in the process. And therefore, the impugned result is assailed in this declaration filed under Article 226 of the Constitution of India. You issue notice to returnable on so you fix date
After
5 weeks. You issue notice on so returnable on so. Next, the petitioner shall serve extra copy of the declaration to the learned CEC in course of the day. Next, the petitioner shall extract within 2 days for service of notice on the respondent numbers 2 to 5 by the registered post with AD. Next paragraph. Having noted that the 10 posts of artisan electricians are required to be filled out of which the select list contains names of 9 selected candidates, comma, 1 post of artisan electrician in the establishment of the respondent number 4 and 5.
My lord.
Should be kept vacant till the next date of listing. Next one, the petitioner shall produce a certified copy of the order before the respondent number 5 to bring this order to the notice of the said authority. Next, based on
17th of July.
My lord, the post is artisan trainee electrician.
write it down.
My
Write it down. due to
My lord.
question.
It is mentioned in the impugned order.
Write it in red.
Oblige.
Item 13.
May I please your lordship? My lord, the petitioner is before your lordship against the termination order at
And issue notice.
Yes, my lord.
Mr. D.B. Bharat and counsel for the petitioner. Agreed by the termination of service by order dated 25/2/2024 and rejection of the appeal by order dated Repeat order is
Order at page 52, order dated 25 to 2024.
Decision of this appeal by order dated 25 to 2024 are assailed in this petition filed under Article 26 of the Constitution of India. Issue notice written over in 4 weeks. Mr. S. Datta, and standing counsel for the PNRD. Department accepts notice of all the respondents.
All the response.
Hence, comma. Issuance of formal notice is dispensed with. Requisite extra copies of the right petition be served on him in the course of the day. This after 4 weeks.
Comments.
14,
Well, this is the third round of litigation,
Just one. Your where is the last order of this court? Which page?
This is annexed 21 of page. It is 110.
Where is the screening committee report?
My lord. Screening committee report, my lord, it is annexed 22.
Page 117 now.
Place 117. And my lord, position was reflected at page 123, serial number 64. my lord.
Serial number
Serial number, my lord, 64. At page 123.
1,
123.
1, 2, 3.
Yes, sir.
Serial number
Serial number 64. my lord.
64.
Yes, sir.
But the minimum requirement is 5 years.
5 years out of
You
7 years.
you are having 31 months.
I have been showing 31 months, but the other records while showing that I working while more than first report is showing more than 15 years.
Where is that?
Yes, my lord. It is also, my lord, in pursuit of the honorable court order. That was at page 133, my lord. 133 and Annexure 24. 133.
33.
Page 133 and Annexure 24. That was in pursuit of the honorable court's order.
But this is in terms.
That was report 2020. 11/11/20.
Then you have to issue notice.
And the period that my learned senior is referring to, this is the period maintained by the field offices, and it has no connection with the experience. The documents pertaining to the experience under the experience head when it comes to a recruitment process as maintained by the HR office. So if my lord sees the report that my senior was referring to, page 121 is the start of the annexure, my lord, the final report. 121, my lords.
Yes.
121, the table, my lords, at the top, experience as given by the field office, experience as per reports. Now, the field office, my lords, as far as the petitioner goes, they had recorded a period of 3245, my lords, at page 123. Now, as per the records of the APDCL, my lords, it is only 31 months. So that is the computation.
Let's say I want to show another.
That can't be.
That is what is.
Yes, that can't be. It can't be if your officers are recording in the field 3245.
Now, that was
5 days.
Right.
So you can't be having a record of 31 months.
These were based on experience certificates given by the officers in the field. Now, when the direction was passed by this honorable court in a writ petition, that you can constitute a committee, look into the experience criteria, see how much experience they actually have. Then they came to a finding that the experience, as far as the petitioner goes, is only 31 months.
It's okay, but those people who have issued certificate, you have terminated their service? No.
That I do not know myself.
Now, interesting document, Mala, I want to solve Lordship, my lord. Kindly have a look at page 138.
So you have a mice at home, mice or mouse, whatever you say, you have it at home. You dutifully feed him, and when he becomes a domestic mice, a domestic mouse, then you stop food for him. Can be.
My lord, Annexure 25. They are.
It's okay, we'll issue notice.
My lord. They are showing I have been working 19 years, my lord.
It's a team answer and counsel for the petitioner,
APGCL
as well as Mr. B. Chaudhary and its standing counsel for the respondents.
So 1, 3, 4, 5, 6, and 7, my lords.
Okay, 1, 3,
4, 5, 6, and 7, my lords.
1, 3, 4, 5, 6, and 7.
Yes. As far as respondent number 3 is concerned, my lord, there is the chairman of the APGCL and the AGCL has also been made a party, my lords. Their names are not reflected.
I have mentioned the chairman, my lord.
Without the employer chairman, the reputation would not be maintainable.
My lord, I in first my lord, the
Uh,
Assam Power Distribution
and-
Council
and
Limited
Mr.
represented by the
TC Suthia, Leonard,
Managing Director.
Additional Senior Government Advocate appearing for file number 2. Your cost schedule for file number 3 is also incorrect.
Yes, my lords.
These are 3 different companies,
But the selection committee was my lord the same, my lord,
common.
my lord. And the first my lord, I have mentioned the director of the managing director of the APDCL, my lord. First one.
The petitioner claims that the field office where the petitioner was working on contractual basis,
It's an outsource.
Outsourced.
as an outsource Sahayak. Under the APDCL had rendered 3 to 5 days of service. Whereas the official records reflect his service to be of 31 months, which led to rejection of his candidature in the selection process initiated for outsourced employees. The present writ petition has been filed under Article 226 of the Constitution of India. Which the petitioner has, whereby the petitioner has challenged the report of the screening committee dated 25/11/2019, wherein his name appears at serial number 64. Lady. Issue notice. Returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned standing counsel. Learned additional senior government advocate, as well as learned standing counsel for the ABDCL within 2 days. Petitioner shall take steps within 2 days for service of notice on the respondent numbers 8 to 17 by registered post with AD. Or we can't issue notice on this respondents. They have not given their address.
Which one, my lord?
It is noticed that the postal address of respondent numbers 8 to 17 has not been provided. Therefore, While permitting the petitioner to provide the correct postal address of the respondent numbers 8 to 17, comma, issuance of notice on them is deferred. Next paragraph. The learned counsel of the petitioner is at liberty to amend the cost title of the respect of respondent numbers 8 to 17 by providing a freshly typed cost title. The AOJ civil rule pending section upon receipt of the same shall incorporate the amended cost title in this requisition and also make necessary corrections in the central registry. Next paragraph. The learned counsel for the APDCL has submitted that APGCL and AEGCL are separate entities. And that the and that in this representation, the APGCL and AEGCL have not been included. So the learned counsel for the petitioner shall take note of this at submission. Next paragraph. In respect of notice issued on respondent numbers 1 to 7, list after 4 weeks.
Upgraded item 40.
Yes, you are referring to default bill.
Yes.
You are referring to default bill. Which provision?
167(2). Well, before that, well, some dates should be necessary
Yes.
and useful. I have charted out the quoted. Part charge sheet was filed on 6/4/2023 on 176 days. Default bail application was filed thereafter on 10/4/23 after 180 days. The 180 days itself. And bail application was filed on 10/4/23 before the trial court. That was my argument for your lordship.
No, but you see,
10/4/23,
Mr. Das,
yes,
in course of many deliberations we do in court, we have come to know about 2 or 3 things.
yes,
Number one, that the forensic science lab
yes,
all over the country is overburdened. Therefore, it's not just possible for the authorities to have a FSL report within the default bail period, this 180 days in NDPS cases. In several of the FSLs, the office is understaffed. The scientific officer level officers are less. And even in Assam, the pendency of giving the report is too high. There are central labs, 2 central labs, they are also overburdened. Therefore,
No.
rightly or wrongly, if a charge sheet is filed, and that constitutes or it discloses sufficient material against the accused person, the trial can still proceed.
No, the question is there. The question is, if the FSL report is not filed and the prosecution itself says that it is a part charge sheet, that means there might be some incriminating materials available. But the final charge sheet, when it is filed, then only the question of knowing the true matter comes to light.
But Mr. Das, there are several authorities, including one of this court, where we have held, and the Supreme Court has also held, that there is nothing called part charge sheet. Charge sheet is only one.
Yes.
So once a charge sheet is filed, whether or not it is termed as part charge sheet.
Part charge sheet means it is incomplete charge sheet.
No, but still the charge sheet once filed, if there's only one charge sheet, the CRPC does not say about a part charge sheet.
No, it is said about the charge sheet and incomplete charge sheet.
You see in this case, please come to the charge sheet. Which page was that?
Charge sheet, page that. Charge sheet 27.
Yes. Now you see page 48.
48.
They say that charge sheet is filed and therefore investigation into the incident case shall continue for collection of further report and evidences, and a report under 178(3) shall be submitted with SCD.
Yes.
Therefore, so far as prosecution is concerned, this can be read that they have filed a charge sheet, but they are continuing with the investigation, and that is permissible.
No, investigation is permissible in a case under section 173(8). After the charge sheet is filed and the prosecution has an inkling of some material more, then it can go and collect those materials. And this is called further
Additional charge sheet.
additional charge sheet. Further investigation. That is called further investigation.
So further investigation is not dependent on the order of the court. It's not
No,
necessary.
no. It is not dependent on the order of the court. It is inherent in with the police. If they get some sort of an hint that there are other materials, then it can collect those materials. But so far as the final submission of the charge sheet is concerned, at that stage it is complete. At that stage it is complete. On the date of filing of the charge sheet, it is complete.
You are relying on any case law to show that to show that if the investigation is continuing, then
A coordinate bench of this court. I have annexed it.
perhaps it is page 90.
Page 86, possible. 86. 77, Raki.
86,
86, 89. And 90, 90, 190. 86, 89.
In this case, the FSL report was not there. Paragraph 7, 87 page.
Yes.
On perusal of the case record, more particularly the charge sheet which has been laid in this case, it appears that it is clearly mentioned in the charge sheet that the said charge sheet is a part charge sheet as forensic science laboratory would not be collected. In Ritu Chabria, the Honorable Supreme Court of India has observed that without completing the investigation of a case, a charge sheet of a prosecution complaint cannot be filed by the investigating agency, only to deprive the arrested accused of his right to default bail under Section 167 of the CRPC. It is further observed that such a charge sheet, if filed by the investigative authority without first completing the investigation, would not extinguish the right to default bail under Section 172. It's 172 is the wrong decision. It should be 167(2). Then, my lord, of the same bench at page 90. At page 110, paragraph 25. Which means, my lord, that it is not completion of the charge sheet. At page 110, paragraph 25, this is the other judgment. Under Section 173(2) of the Code of Criminal Procedure, the officer in charge of the police station has to forward the police report in the form prescribed by the state government, that is the charge sheet or the final report, as soon as the investigation is completed. Though the Code of Criminal Procedure does not prescribe the time limit for completion of the investigation of a case which relates to offense punishable with death, imprisonment for a life, or imprisonment for a time not less than 10 years. However, if the said investigation could not be completed within a period of 90 days from the date on which the accused person has been forwarded to the magistrate, if he is arrested and detained in custody, no magistrate shall authorize the detention of such an accused on the expiry of the period of 90 days. And the said accused shall be released on bail if he is prepared and does furnish bail. In paragraph 26. In this case, paragraph 26, 27, and paragraph 25, 26, and 27. Which of the- Paragraph.
you go through the LCR and tell us when the samples were sent for FSL.
FSL, it was sent by our. What it was. G20. Right. Page 48.
You will find out, don't worry. You will find out when the FSL is sent.
When the FSL report was sent. No,
Yes.
when the G29 was, sample was sent.
Yes.
But the FSL report was submitted on 8/5/23.
Where is that?
It is said at page 67.
67.
67.
So that will contain the date.
That contains the date. It is the order of the trial court. One FSL report has been submitted in connection with the voice analysis of the charge-sheeted accused Ahmaduddin Tapadar by IO on so and so. Hence, considering the material, I do not find that the charge sheet submitted is incomplete.
Something is missing. This page 67 and 68 are not in continuation.
67, 68. I go from considering the application. I go from considering the application for the देखो तो नहीं, I'll check it out.
I think it will be there in the record. You see,
No, original.
no, we will have the scan copies are there.
Yes.
I'll tell you what has happened. Why I'm thinking so.
Yes.
Page 67,
Yes.
the last word is exhibit was found to be 70.24.
Oh, no.
Correct.
No.
Page 67.
Page 6, I am holding different. Considering an application. Oh, no. Considering an application.
Oh, no, that is, I'll tell you what has happened. Acha. Okay. Yes, page 41.
Page 41.
Yeah. Page 41, the last line,
Yeah.
last few words are exhibit was found, heroin in the exhibit was found to be 70.24. Correct. And the next page, it does not say gram percentage or whatever. It's something different.
Page 41, my lord, your lordship is reading.
41 last words are heroin in the exhibit was found to be 70.24.
Yes, yes.
70.24% or 70.24 gram. So that word is not there. So therefore, it appears that page 42 is not in continuation to page 41.
Page 41, 42. No, which is yes,
No, he'll find out because
yes, in the record it will be there.
it will be
But
recorded there.
certificate copy is that.
Just find out
Yes,
from the scan copy of the LCR.
yes.
And if it is not there, we'll have to call for the correct one because if and
Ought to
second,
be 17.24. What is that? What is the unit?
yes, Mr. Das,
Yes.
we will take it up at 2 o'clock.
Yes.
Let them find out. And there's another query of the court. You will contact the FSL and obtain information why there was a delay.
Yes.
Why within this period it could not be done. Correct? Instead of theorizing, let us have the
Yes.
original feedback.
Yes.
At 2 o'clock, we'll take it up. Because there's, Mr. Das, why I'm deferring it is one more reason. I'll be required to do some research because I have not come across any case laws. Obviously, I have not searched that thoroughly, but I have not come against any case law which says, you see, what happens in an investigation? The IO does an investigation. For certain reasons, he has to depend on the FSL.
Yes.
But let us say there was a murder, suspected poisoning, so the viscera is sent. Now, that report is not within the control of the IO.
Yes.
So he otherwise, let us say in a murder case, he finds that there's a strong suspicion with regard to murder by administration of poison, and therefore the charge sheet is complete, and therefore charge sheet is laid before the court, and then says that the viscera report. You see, what happens is that the postmortem is done at medical college at
Yes.
Guwahati. Let us say Guwahati. They collect the viscera and give it to the IO, and IO sends it to the FSL. So therefore, the FSL report is not within the domain of the investigating officer. So therefore, if there is some other delay, we'll have to lay down a
Yes.
prescription. So what will happen if once this delay is
Because
for
it
the
is
IO.
not in the hands of the investigating officer.
Yes. So therefore, if the authorities do the delay, then there has to be a direction to the authority to the forensic administration to increase the number of that. Because the privacy satisfaction is recorded because when the drugs are seized,
Yes.
a privacy satisfaction in the presence of the seizure witnesses, sample test is done to have a trace of
Yes.
drug
Sample
being
test is
there,
done.
and then it is sent. So these are the reasons why I'm right now adjourning it till 2 o'clock. You have to tell us,
Yes.
correct? I'll take a short break and come back. Critical.
Item 15, my lord. My lord, in the detailed medical examination, my lord, two candidates were appeared. That is the petitioner and the respondent number 5, my lord. But the respondent number 5 has been rejected in the detailed medical examination, my lord.
Okay. You're there, we are issuing notice. I had Mr. V. Kumar, counsel for the petitioner, and Ms. R. Devi and CC appearing for the respondents. Number 1 to 4.
1, 2, yes, that's.
Where is your application for review medical?
Review medical, my lord, that is page number 18.
Page number
18, my lord.
18.
Yes, my lord. That is the detailed medical examination, my lord.
No, you'll have to ask for review. Where is that?
My lord, I was selected in a detailed medical examination, but respondent number 5 was found unfit in detailed medical examination. He has not applied for the review medical examination, my lord, as per the policy. His review medical examination was conducted after the 7 days, my lord. That is against the policy, my lord.
No, but you have not challenged his appointment.
Appointment of
Respondent number 5 is not under challenge, so therefore that inquiry can't be made. What has happened to him, we can't, we won't direct an inquiry.
I have challenged the appointment of the respondent number 5, my lord.
You read your prayer, I don't find it.
My lord.
Oh, setting aside respondent number 5, okay, it's there.
My lord.
Okay. The appointment of respondent number 5 has been challenged by the petitioner by filing this petition under Article 226 of the Constitution of India. Next issue. (21) to 2024, this petition is filed under Article. You should notice the returnable in 4 weeks. Requisite extra copies of the petition be served on the CEC in the course of the day. Next, the petitioner shall take steps within 2 days for service of notice on the respondent by registered post with AD. Next para, the appointment of respondent number 5 shall be subject for the orders that may order within bracket S order that may be passed in this petition.
My lord. Deeply lodged.
Item 16.
May I please your lordship?
Yes.
Lordship, the petitioner before you is an assistant executive engineer working in the PNRD department. The facts of the case is this, your lordship, that the petitioner is staying separately from his wife since last 3 years. And lordship, to that effect, he had filed an.
Oh, you see, somewhere your projection in your petition is that you are not married twice, but you are maintaining a relationship with another female.
Lordship, that is, lordship, it is a fact that I have a son
No,
from
that's
that.
okay. But you see, there are various judgments which says that continued relationship is it is an acceptance of the person living together, and therefore it has the same connotation of that of a marriage.
Lordship, this is my case, lordship. Lordship, I am challenging that inquiry report because of that. They are saying that this is bygamy, but lordship, no. That lady, she is independently raising that child, lordship, and lordship, to that effect, neither she has claimed that she is my wife, or in future also she is not claiming to be my wife until and unless I get divorced from my legally wedded wife. So lordship, at this stage, at least they should bring on record how in the inquiry report, how they have found in the inquiry that I have a legally wedded wife. At page number 24, lordship, in the inquiry report, the relevant portion, lordship, they have categorically stated that in the inquiry they have found that I have 2 wives, lordship. It is a, may I read your lordship, page number 24, lordship. This is the
Yes.
inquiry report.
it is a fit case of adultery and attract relevant sections under civil services conduct rules, wherein it is not proper on the part of the government servants to have more than one legal marriage wife. So Lordship, this is my case. I have only one wife, Lordship, and Lordship, and the lady, she is not my wife, Lordship. So now, if the departmental proceedings is to be initiated, then on the basis of this inquiry report, the actions will be initiated against me, Lordship. This is my grievance, Lordship.
Does he give you Evidence Act? It's not yet. Evidence Act. Evidence Act. In this, Haji. This is section 50.
Lordship. Opinion on relationship when relevant.
Now, after this, you'll have two illustrations.
Lordship.
Read those illustrations that will explain the section 50 more better.
Lordship.
Please read that.
I read, Lordship.
Yes, definitely.
50. Opinion on relationship when relevant. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship or any person who, as a member of the family or otherwise, has special means of knowledge or on the subject is a relevant fact, provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act 1869 or in prosecution under section 494, 495, 497 or 498 of the Indian Penal Code.
Next illustration.
Illustrations, Lordship. A. The question is whether A and B were married. The fact that they were usually received and treated by their friends as husband and wife is relevant. B. The question is whether A was the legitimate son of B. The fact that A was always treated as such by the members of the family is relevant. Lordship.
So here you see, it's only an opinion expressed, whether there's a relationship or not. There's a child.
Lordship.
So therefore, how it is perceived, what is the relationship perceived is a question within the meaning of section 50 of the Evidence Act.
Lordship.
There's one part. There's another part. You see, a declaration as to the existence of relationship cannot be given by the court unless that party is before us. So you see, you have a lady with which you have a relationship, you have a child with that lady, and you are asking this court to give a declaration that you are not a legally married wife. That the lady is not a legally married wife. This is a declaration which we can't give in the absence of the party.
Lordship. Lordship, I humbly want to submit this, Lordship, that let the notices be issued. Lordship, till that time, the party which is absent here, that party may be impleaded by way of a miscase, and that party files an affidavit that whether she's, what is her stand, whether she claims to be the wife of the petitioner in concern, Lordship.
Okay. Okay, accepted.
Lordship.
Dr. Purvi Mehdi, counsel for the petitioner, as well as Mr.
U Sharma on behalf of Mr. S. Datta.
Mr. U Sharma, counsel appearing on behalf of Mr. U Datta, standing counsel for the PNRD department, representing the
Yes, both the
respondents, both the respondents. Next one. The you are only asking for a question of the inquiry report.
Lordship, because that inquiry report, on the basis of this inquiry report, they have initiated a DP, Lordship, and this is the basis on which disciplinary actions may be initiated against me, Lordship.
But we won't be stopping the disciplinary proceeding.
Lordship.
It can't be stopped because once they're taking it up,
Lordship.
we don't know whether they will accept it or not.
Lordship.
You will be aggrieved only when the departmental proceeding is culminated.
Lordship.
By the inquiry report, how you can say that you have been prejudiced?
Lordship.
The report is only a report. How would a writ be maintainable for against that report?
Because they have already, on the basis of this inquiry report, they have formed a
No,
basis.
you see, the question of the court is, you see, this inquiry report does not create a right in favor or in adverse to the petitioner.
Lordship.
Therefore, it's only a report. Your rights is neither created nor taken away by this report.
Lordship.
It's a report is merely an opinion expressed. And therefore, it is the disciplinary proceeding, ultimately the decision taken in the disciplinary proceeding, which you can be said to be aggrieved.
Lordship.
In a report, how can you be an aggrieved person?
Lordship, at page 21, Lordship, they have issued a notice to me, Lordship.
No, that is something else. There's a consequence. There's a consequence.
Lordship.
In a disciplinary proceeding, at the issuance of show cause notice, has a case been made out to stay the proceeding itself? You see, it's an opinion expressed. It's not a culmination of the disciplinary proceeding.
Lordship, after the inquiry report was submitted, the department has issued a notice to me, Lordship, at page 21, Lordship. Yes, at page 21, Lordship.
Can we examine the veracity of the report? Unless the report itself is accepted by the authorities. It's, you see, some allegation is made. A alleges that B has indulged in corruption.
Lordship.
A show cause notice is issued. But there is an allegation by A that there is a corruption and show cause notice is issued.
Lordship.
There may be an inquiry, there may not be an inquiry.
Lordship.
Is it a mandatory requirement that before a show cause notice in a departmental proceeding is issued, there has to be an inquiry? No. It is the satisfaction of the authorities that they want to proceed against you. Correct. Please correct me if I'm wrong.
Correct. You are correct, Lordship.
Please correct me if I'm wrong.
Lordship.
So you see, this there's a report on the basis of which a departmental proceeding is issued. How far we can interfere with the departmental proceeding?
Lordship, I am aggrieved because, Lordship, since the opinion has already been formed, Lordship, because of that opinion, it will always, Lordship, have a prevalence, Lordship, over, Lordship, it will be very difficult for me to override that opinion, Lordship, because I will be always considered as I have two wives, two legally wedded wives, and on that basis, Lordship, the entire proceedings will be initiated.
No, perhaps, Dr. Mehdi, you are wrongly advised.
Lordship.
You know, a report is only a report.
Lordship.
I've learned things in a hard way.
Lordship.
But the problem is that I can't shake out CPC from my head.
Lordship.
According to Order 26 Rule 10.2, any report created is an evidence. But that evidence has to be tested by examination and cross-examination of the witnesses. So therefore, if there is a report, the author will be there in the department proceeding, you have to cross-examine and dispel that. So that is how I've learned things. So therefore, when there is a report, now you are asking the court to examine the veracity of the report. How can the writ court examine the veracity of a report, which is the basis of an inquiry? This shows the law that the correctness of the inquiry report can be gone into by the writ court before combination of the discipline proceeding. If there is any case law on the point, you please show us. We'll take it up at 2 o'clock.
Not sure.
Because then we'll be flooded with thousands of disciplinary proceeding cases. Everybody will come and say that they have charged me for X. Please examine it. It is not workable.
I understand, Lordship.
So therefore, prior to departmental proceeding, there will be an opinion of the court.
Lordship.
Please show me the law in this regard.
Lordship.
2 o'clock.
Item 17.
Let me, Lordship. This is also a matter of selection and appointment, my lord. But wherein the post is reserved for the ST category, but the candidate has been selected from the OBC category, my lord. But I am praying for only notice, my lord, at this stage.
So OBC category.
Yes, madam.
Okay. Mr. V. Kumar, counsel for the petitioner. And Mr. D.R. Bora and CEC appearing for the respondent numbers
DC Bora.
1 to 4.
DC Bora.
DC Bora. What did I say?
Lordship.
What did I say? I said wrongly?
DR Bora.
Oh, acha, DC Bora. I'm sorry. I'm sorry. The appointment of respondent number 5 is under challenge in this petition filed under Article 226 of the Constitution of India on the ground that he was selected an appointment, though he was an OBC category candidate, he was selected and appointed.
Not that appointed, Lordship. Only selection has been made.
Selected as a in the post earmarked for
In
SC
the post
category.
of, he is not for SC category, my lord. In the post of rifleman recovery vehicle.
No, he's a SC category.
Selected candidate is from OBC category and the post is for ST category.
Acha, it was a OBC category, and the post for which recruitment is sought to be made is reserved for SC category.
ST, madam.
ST category. The post of rifleman within bracket recovery vehicle, for which he was selected, is earmarked for ST category. Issue notice. Written about in 4 weeks. Requisite extra copies of the requisition be served on the CEC in course of the day. The petitioner shall take steps within 2 days for service of notice and respond number 5. The rest will post be ready. Next. The selection for the post of rifleman in bracket recovery vehicle shall be subject to further order in bracket as that may pass in this resolution.
Be clear, Lordship.
Obliged, Lordship.
Item 18.
Yes, again the DLR.
Lordship, only
Yes.
petitioner is son of the earlier Gram Pradhan, Lordship. And the private respondent who has been selected, he is a member of the political party. You have annexed the document.
And immediately thereafter, we have filed an appeal before the authority. And we also filed an application for early hearing. So they are not hearing.
Which is the document of political?
Lordship.
Where is the document?
Lordship, kindly see page 19.
19.
19. Serial number, Lordship will find page 20. Roman Buja Borwa.
Page 19.
Page 19.
Okay.
Serial number 23. 20. Roman Buja Borwa has been selected as the Gapradhan. He is a member of the political party.
We'll have to stay this. Although so long we have not been interfering.
Actually, DLR, he is one of their out of state. So, he is in the election duty and MP lordships.
But you
Only
see,
because of
long
that, my
back
lordship was pure pen.
but you see,
Time frame, my lord, it will be difficult for time frame, my lord.
I understand, but then it has to be stated. If he is showing documents of political affiliation,
No, my lord. He says political documents, he may be resigned. I don't know, my lord. That's why let
that
him
is
come,
okay.
let him come, my lord.
No, but that has to be stated. If political affiliation is there, then there are other considerations.
No, maybe, my lord, everybody may be a member of the political party. Where he get the job, my lord, he may be resign. Otherwise, before that, he may resign. That
No, I
is-
don't know. Let the government approval be made so that even I can try my luck.
That's
Let there be a government policy.
a government
I
policy.
may also try my luck. I don't know.
So, responsible 6, let him appear. Otherwise, he is paying, I think, one case is an annex here, my lord.
No, he's filed an appeal.
Appeal, my
And
lord.
this, you see, this is a multiplying case. This DLR, so many writ petitions we have got where the appeals are not being taken up.
And as per page 14, Lordship, he must not be a member of the political party, registered political party. That is the criteria.
Where is that?
Page 14.
14.
Page 14. Type copy. Annex 1. Serial number 8.
8, serial number 8.
Lordship. Applicant must not be a member of any registered political party.
Serial number 8.
Eligibility criteria. Serial number 8.
Heard. Mr. S.K. Goswami, learned counsel for the petitioner.
Only because, my lord, lordship is disposing of the matter.
No. I have issued notice.
Yes.
And this pendency will not be a bar for the appeal to be taken up. Because since I am staying it, I can't dispose it off.
Respondent 6 has already been appointed, my lord.
So his appointment is subject to the result of the case, Lordship.
Maybe, my lord. Otherwise, he is otherwise to my lord, dispose of the appeal pending before a
But you see, you are saying that it will be difficult if he is engaged elsewhere.
He has already been appointed.
Lordship, we have filed application on 23/2/2024 to the Director of Land Records. And he has not taken the matter. That is why he was appointed. Page 20, Lordship.
That cannot be because
Election has come
going on, my lord.
hereafter.
Pardon me, I did not get it. Please.
Page 20, Lordship.
20.
Thereafter, Lordship, code of conduct. They are saying that he is not attending the observer. Page 20, Lordship. The application for early hearing. It was filed on 23/2/2024. For considering the interim pair.
Let the appeal be disposed of, my lord. We have nothing to say. Let the appeal be disposed of.
No, it's okay. We can take it up tomorrow. You will tomorrow or day after tomorrow. Please tell us when they will be disposing it off. Because if they are not taking up early hearing petitions, they are not taking up the appeal, and the petitioner is showing that he is a member of the political party.
Then that will be replied by the respondent 6, my lord, whether he is a political party
It is
member.
okay. If he is wrong, he will pay costs.
My lord, That's why
Damages, suit for compensation, damages.
he's a board committee member. Board committee
And
member
he-
is not an active member of the political party. And now, I think, my lord, perhaps he resigned, he knows about the,
No, that we'll know only after I join political party, whether a booth member is important or not. I don't have any personal knowledge. So,
let a notice be go, my lord.
yes,
Party.
because I don't know, without good people in the booth committee, a political party can win election, I don't know.
Yes, ma'am.
Some experience is lacking.
No, so far I know, my lord, to some extent, I have a relation with the political party also. Board committee member is not a, my lord, they are active politician. Until and unless there is having a designation, a secretary, vice president, otherwise president of the district like that. Whatever may be,
I don't know, we are live.
his allegation is there, but that would be countered by the responsible.
I don't know, we are live. So the booth people know about the stand of the government in for booth. Active politicians in booths. they were-
Actually, board committee is when it consisted, when election comes, then board committee is consisted to look after the situation.
After that, there are booth committees.
Board board person, day after the board committees.
Good. Mr. S.K. Goswami, Council of the Petitioner, Mr. E.C. Tritiya, and Additional Senior Government Advocate, appearing for respondent number
3 and 4,
1.
my lord. 3 and 4 and 5.
Okay, 3, 4, and 5. And
Mr.
Mr.
Handik,
J.
1 and
Handik
2.
Leonard, County Council for the Revenue Department, appearing for respondent number 1
And two.
and 2. The case of the petitioner is that he is the son of
Village Gam Pradhan.
village Gram Pradhan, or it is Gaon Pradhan?
Gaon Pradhan. Gaon Pradhan.
Gaon Pradhan. And he had offered his candidature for the post of
After retirement of his father, lordship, post was set advertised.
for the said post of Gaon Pradhan. After retirement of his father, in respect of village Kundor, Kundor, Gaon, under Gograpar Revenue Circle. What's it? 3 villages, Kundargaon, comma, Jabari Hat, Jabari comma, Barja Barihati, Barjabari, comma, number 2, Bardhonora. Synopsis. Under
Number 2.
Gograpar Revenue Circle. However, in the selection process, the respondent number 5 was respondent number 6 was selected. Agreed by the result, the petitioner has filed an appeal before the Director, Land Records and Survey from Assam, which is registered as appeal number 7 of 2024. Filed under instruction numbers 162, capital C, of the Assam Land and Revenue Regulation, 1886. 162 dash C, bracket, no bracket. First one. Next, the Learned Counsel for the petitioner submits that there was a delay in adjudication of this said appeal, and therefore on 23 through 2024, the petitioner had submitted an application for early hearing. But till date, the appeal hearing has not been taken up in respect of his appeal. Next
For
para.
considering the intent in prayer, lordship, we have prayed.
only in consideration of interim prayer. As neither the interim prayer nor the appeal has been taken up for adjudication, the present writ petition has been filed under Article 226 of the Constitution of India. Next, in support of the prayer for interim relief, the learned counsel for the petitioner has referred to which is that page?
Page 19. Annex 4. Page number 20.
Just a minute.
Page 19.
Just one. The learned counsel for the petitioner has submitted that as per clause 8 of the employment advertisement, it is provided that where is that page?
Page 14, Annex 1.
The applicant must not be a member of any registered political party. And in this context, by referring to Annexure 4 to the writ petition, this is a list of political party for the Gograpar, GHO, GRA, PAR, Mandal Committee. It is rejected by the petitioner. The respondent number 6. Is the convener of booth numbers 187, 188 and 189. So accordingly submitted that the respondent number 5 could not have applied and selected in the process.
6, looks.
Okay, that's number 6. Next, issue notice returnable on when, Mr. Shitya?
4 weeks, my lord.
Returned in 4 weeks. Requisite extra copies of the petition be served on the learned additional senior government advocate and the learned departmental counsel in course of the day. Next, the petitioner shall take steps within 2 days for service of notice and respond number 6 by registered post to the DD. Next, as an interim measure.
So far interim is concerned, my lord, my submission is Annex 4 is a, my lord, it is not a, my lord, paid of the Bharatiya Janata Party, neither there is a date of this statement. When it was made, just to make out a case, my lord, if it is annexed, but I don't know.
Let them challenge that, lordship.
No, but definitely the date is not there when it was made. He
No, we
may-
don't know, Mr. Zutia, but what has happened is that I have checked up. This Annexure 4 is supported by statement made in paragraph 11. And paragraph 11 in the affidavit is supported by record. So he takes the responsibility of giving a false statement before the court.
I will become responsible.
This is idea. Opposing the prayer for interim relief, the learned counsel, the additional senior government advocate has submitted that Annexure 4 to the writ petition is neither in the official letterhead of the
Bharatiya Janata
particular
Party.
political party and does not bear any signature. It is also submitted that as per instructions received by him, the officer who is holding the post of Director of Land Records and Survey, Assam, has been signed duty outer station for the ensuing Lok Sabha elections, for which there is a delay in the adjudication. That's what as an interim measure, the court is intended to provide that in the event the Director of Land Records and Surveys, Assam, within bracket respond number 2, does not take up the prayer for interim relief of the petitioner within 7/6/2024, on and from 8/6/2024, the selection and constitutional appointment, if any, of Raman Buzar Barua, respond number 6, as the Gaon Pradhan of so and so, shall remain state till adjudication of the prayer for interim relief by the said authority.
My lord, his prayer is not to confirm till disposal, my lord. His interim prayer, lordship kindness may not be stayed, my lord. He has already joined, I think, my lord. So his interim prayer is not to confirm his service.
Page 33, lordship.
Page 33.
33.
Sure.
33, appeal.
Not that, when you say that the appointment of respondent number 6.
Appeal, my lord, that is.
So and so shall not be confirmed, and or final appointment of the
Disposal of
respondent
the.
should not be made to the said post.
Not to confirm, my lord.
Not to confirm.
Yes, that much.
Okay, resume at 2. I'll maybe 5 minutes late in coming.
Obliged.
Let's make my lots permission, my lord, may I mention item number 44 and 45, my lords.
The arbitration matters.
But that
Okay, we'll
arbitration,
take it up.
that is deeply obliged, my lords, deeply obliged.
What you said,
D29, lords.
But then you cannot save this case from default bail. You see, FIR is lodged on 11/10/2022. Petition is arrested on 12/10. The charge sheet is submitted on
6/4.
6/4/2023.
2023.
Now this FSL report
Okay.
is dated 14/11/2022. That means it was available. So the charge sheet could not have been partly submitted by saying that we'll collect the FSL report. The FSL report is already there.
Only voice sample lordship is there, not.
D29 is about voice sample. At page 37, your lordship.
Only lordship.
D29 is about voice sample.
Whether the substance is narcotic or not, it is there. But the voice sample is not there, lordship. So it cannot be stated that it is incomplete, lordship.
Page 39,
Page 37,
37.
D29. FSL forwarding of seized mobile phone belonging to Ahmaduddin Tapadar. By MR number so and so. It is not with regard to the contraband article.
Okay, okay. Okay.
FSL, that report was submitted on 8/5 at page 67. That was on 208 days.
Where is the order of the Supreme Court?
My lord,
Where is the order of the Supreme Court?
this honorable court, Supreme Court. I am banking upon Ritu Chabaria. Ritu
No, no.
Chabaria is it?
In this case, what is the observation of the Supreme Court? Have you annexed that order, Supreme Court order?
No, Supreme Court, we did not approach the Supreme Court.
No, you're referring to this page 67. Second paragraph in page 67 is Supreme Court order in which permits you to.
Oh. Very good. Very good. Okay. Specially petition number. Very bad.
Lordship, I have also found one citation, Lordship, regarding this part, Lordship, regarding part.
Okay, we'll get it. Don't worry. Ritu Chabaria is 2027 SEC.
2023, yes.
Zero H, zero.
It is, my lord, SCC online, SC, page 502, 2023.
23.
23. Copy letter. Copy name. The main contention of the question is a paragraph, well, it will be paragraph possibly in SCC online, it will be paragraph 10 possibly, but it is here 9. Same copy, no? Paragraph 9, your lordship, please to see. The question is whether the investigation is complete or not. Because the emphasis on of the different provisions of the law, CRPC, that every investigation has to be completed. The question number 1 was framed in that line, that can a charge sheet or a prosecution complaint be filed in piecemeal without first completing the investigation of the case? Whether the filing of a charge sheet without completing the investigation will extinguish the right of the accused for grant of default bail. Thereafter, your lordship will be to see paragraphs in this copy, paragraph 23, 24, 25, 26, and 27 at page 9. Paragraph 23, 24, 25, 26, and 27. And 32 also.
Okay. This order you are relying on which paragraph?
Lordship. Paragraph 4 is the question raised, Lordship. And in paragraph 18, Lordship.
18.
Paragraph 4 and 18.
Okay, let me go through it.
But I have some case laws, my lord.
Yes, yes.
But I will not cite, I will only cite those decisions because your lordship has dealt with all these things in a number of cases. I will only give the paragraph. First, my lord, 94-5 STC 410. Sanjay Datta's case.
94-5 SCC.
410. Paragraph 48 and 53 bracket 2 bracket B.
Yes.
Then 2001 5 SCC 453.
Yes.
That is Uday Mohanlal Acharjee. Paragraphs 30, 13.1, 13.2, 13.3, 13.4, entire paragraph 13 up to 13.6. Then the celebrated case of Rakesh Pal, 2017, 15 SCC, page 67. Paragraph 7, 8, 9, 17, 28, 29, 33, 35, 36, 40, 41, 46, and 47.
Yes.
Then 2018, 16 SCC, it is Ashok Mundilal. 2018, 16 SCC, 158. Paragraph 5 only. Then 2021, 2 SCC, 485. M. Ravindran. Paragraphs 2.1, 6, 7, 17.1, 17.4, 17.7, 17.11, and 18.3. Then 2022 10 SCC. This is Satendra Kumar until your lordship has dealt with the matter. 22 10 SCC, page 51. Satendra Kumar until versus CBI. This is only paragraph 39. And lastly, my lord, Ritu Chavaria, 2023 STC online 416 naki
502.
502. That is paragraph I will given. But in the, my lord, my copy may not tally with,
No,
but
so you have given a
STC
copy.
online,
It's okay, you have given us a copy, para 9 and.
yes.
We marked it.
Para 9
And
and my lord, 25 was possibly
23 to
23,
28.
24, 25, 26,
Okay,
27, and my lord, possibly 33,
yes,
32.
we marked it.
Yes. These are the cases.
Mr. K.K. Das, Mr. B.C. Das, and the senior counsel, assisted by Mr. S.H. Rahman, counsel for the petitioner, and Mr. K.K. Das, the APP, appearing for the state. Submissions are concluded. List on Friday for delivery orders.
Friday. But we may not come on Friday, that is the problem. My junior also may not come.
Okay.
But somebody must be present
You're on Tuesday then?
next Tuesday. Yes.
28, 5.
28/5.
Time being item 16.
May it please your lordship. The lordship is very much correct that the scope of judicial review regarding departmental proceedings, departmental inquiry is very limited. However, lordship, under special circumstances, a departmental inquiry can be interfered with when the inquiry is conducted against the established principles of law. And lordship, here in my case also, lordship, when the delinquent officer, the petitioner, along with the lady in concern, approached the inquiry officer and have expressly told them that there is no legal marriage, and they have produced all the relevant documents. In spite of that, the inquiry officer did not accepted those contention. Therefore, lordship, I humbly submit that this is a fit case, lordship, where an inquiry report can be interfered with. Lordship, in support of my argument, lordship, I am pressing one case law, lordship. Citation is 2013 6 SCC 515. One copy. A copy of the 2013 6 SCC 515, lordship. The name of the parties are Anant R. Kulkarni versus YP Education Society and others. Lordship. Lordship, here in this case, Lordship, the inquiry report was set aside, Lordship. Lordship, the relevant portions, Lordship, I will read out paragraph 11, Lordship, where the importance of an inquiry, paragraph 11, Lordship, where the importance of an inquiry is emphasized. May I read, Lordship? The purpose of holding an inquiry against any person is not only with a view to establish the charges leveled against him or to impose a penalty, but is also conducted with the object of such an inquiry recording the truth of the matter. And in that sense, the outcome of an inquiry may either result in establishing or vindicating his stand, and hence result in his exoneration. Therefore, fair action on the part of the authority concerned is a paramount necessity. And Lordship, ultimately, Lordship, it was held in this case, Lordship. I will take Lordship to paragraph 28 and 29, Lordship, where it was held, Lordship. 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 2.3, Lordship. 2.E, Lordship. An inquiry committee Lordship. 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 Lordship, I'm just trying to highlight the query Lordship has raised that E, Lordship, E. An inquiry committee consisting of 2 members instead of 3, as per rules 1981, conducted the inquiry and submitted its inquiry report on so-and-so, making a recommendation that the appellant be dismissed from service. The said inquiry report was accepted by the management committee, and the services of the appellant were terminated while order dated so-and-so with effect from so-and-so. And F, aggrieved that appellant challenged the said termination order by filing appeal number so-and-so before a tribunal. The respondents contested the appeal. However, upon reaching the age of superannuation, the appellant stood retired on so-and-so. Lordship, Lordship, Lordship. And at 28 and 29. Lordship. 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 Understand, Lordship. Lordship, if I may put it like this, Lordship. Lordship, since my grievances with the inquiry report, Lordship, can it be done, Lordship, that this inquiry report may not be concluded, may not be accepted as a conclusive inquiry, and because, Lordship, why I'm aggrieved is because my contentions were never heard. Yes, Lordship, yes, the DP may accept it, may not accept it, Lordship. Lordship. No, Lordship, no. I will have to face, I will face. But Lordship, this report will always have a bearing in mind the DP.
Lordship. Lordship, the
Lordship. Lordship. Correct, Lordship. Lordship. On.
Where after the charge sheet is filed and after these preliminary investigations are carried out by the CBI or by the NIA, the trial has never led to acquittal. So report is only a report. When it comes to the scrutiny of the court, I can't say. Lordship. You're closing with, we permit you to make a challenge to the report in any other manner you can.
Lordship.
Heard Dr. P.P. Medilan, counsel for the petitioner, and Mr.
U Sharma appearing on behalf of Mr. S. Datta.
Mr. U. Sharma, and counsel appearing on behalf of Mr. S. Datta, standing counsel for the PNRD department,
For both the respondents.
presenting both the respondents. Next paragraph. The petitioner is presently posted as Assistant Executive Engineer, Dhemaji Development Block, under the PNRD department, Government of Assam. Full stop. In course of his service, the petitioner was issued a show cause notice dated 22/3/2023 containing allegations which may not be spelled out in this order. Lordship. Full stop. The petitioner submitted a show cause reply and the full stop. Thereafter, the disciplinary authority ordered an inquiry on 4/7/2023 to inquire into the charges brought against the petitioner. Full stop. The inquiry report was inquiry report dated 22/4/2024. Was submitted by the Joint Secretary to the Government of Assam, who was appointed as the inquiry officer. Recommending that the relevant provisions of the Assam Services Conduct Rules were attracted in the case. Full stop. Next, but agreed by the said inquiry report dated 22/4/2024. The petitioner has filed this writ petition under Article 226 of the Constitution of India. For setting aside the said inquiry report with a further prayer to stay the departmental proceedings initiated against the petitioner. Next paragraph. The learned counsel for the petitioner. As some matters which are related to personal life of the petitioner is involved, the court is of the considered opinion that the nature of allegations may not be reflected in this order. And therefore, the facts which invited the disciplinary proceeding against the petitioner is not narrated herein. Next paragraph. The learned counsel for the petitioner has submitted that the report, the inquiry report contains finding that are prejudicial to the interest of the petitioner. And that it is alleged that the inquiry was conducted in a partisan manner without taking into consideration the stand taken by the petitioner. So accordingly, it is submitted that the inquiry report, that the inquiry was conducted in an illegal manner, and the report itself is vitiated for the illegality. So in support of his submissions, the learned counsel to the petitioner has referred to has cited the case of Anant, ANANT, R. Kulkarni, KULKARNI versus Y. P. Education Society and others. AI 2013 SC 2098. In this regard, the solutions made by the learned counsel for the respondents Next para. Without entering into the merit of the inquiry report. Court is of the considered opinion that an inquiry report, the merely a report, has to be sustained by the departmental authorities during the hearing of the disciplinary proceedings. And at that time, the petitioner would have all opportunity of cross-examining the witnesses and or the author of the said inquiry report. Next, in cases involving departmental proceedings, the court, the constitutional courts ought to be slow in examining the correctness or otherwise of the inquiry report, which is not yet crystallized into a finding of the disciplinary authority. Full stop. Even if the disciplinary proceedings are answered against the delinquent employee under the Assam Services, even bracket discipline and appeal, bracket those rules, 1964. There are provisions for appeal by the aggrieved. Full stop. Moreover, the petitioner will still have an opportunity of questioning the order passed by the disciplinary authority as well as the appellate orders by approaching this writ court. Approaching the writ court. Next paragraph. The case of Anant R. Kulkarni, cited by the learned counsel for the petitioner, is not found to help the petitioner in any way because of the fact that pursuant to the inquiry report submitted in the proceedings referred in the said case, the petitioner was terminated, and the termination order was challenged before the appellate tribunal, and the tribunal had quashed the termination order. Thereafter, the management approached the writ court, and the orders passed by the writ court directing the respondent, the authorities to proceed with a fresh inquiry on the delinquent employee and approach the Supreme Court of India. Therefore, said case is not an authority on the point that an inquiry report which is not yet accepted as an admissible evidence was interfered with by a constitutional court. Next, madam. Accordingly, the court does not find this to be a fit case for interference with the inquiry report dated 22 2024. Next paragraph. Nonetheless, parting with the records, it is made clear that as the court has not entered into the merit of the charges framed against the petitioner or on the merit of the inquiry report, it is provided that this order shall not preclude the petitioner from challenging the inquiry report in such manner as petitioner may be so advised, either in the disciplinary proceedings or any steps taken thereafter. With the said observations, Congress represents closed.
I'm obliged, your lordship.
19.
Please, your lordship. Matters related to non-appointment under compulsion and ground, lordship.
2015.
Lordship.
Why should we interfere now?
The thing is that, lordship, the petitioner father was dismissed from service, lordship, in the year 2013. Then in the 2015, he expired, lordship. Then his petitioner mother had filed an appeal before the appellate authority, lordship. That is case number 18, lordship.
You see,
Then appellate
I'll tell you two things. The restoration of the service of the petitioner was done. But yet you see, on the day when your father died, he was not in service.
Not in service.
So it is post facto reinstatement in service so as to enable him to get all the pecuniary benefit.
Only the pension benefit, lordship.
Now all
So-
services benefits are given.
Not-
I understand, but dying harness will not revive. You have to show us that the dying in harness will also revive. But on that day, you were not in service. Your father was not in service.
No, I was not in service. My father not in service. But appellate authority had order dated lordship 10/11/2020 lordship. First order 10/11/2020 lordship.
No, correct, reinstated.
But lordship, the remaining period was considered as dies non period, lordship. The remaining period, lordship, that was considered as dies non, but no work, no pay, lordship.
No, that is different. He's not arguing on that. He's saying that once the service is restored, the dying in harness also revives. Diasnon means he is in service. Diasnon is not that he is not in service. He is in service for all period. That means it's the period of suspension or termination that is accounted for, and he is treated with doing service on those days also. So he gets the salary and other benefit. That is Diasnon.
Lordship.
But dying in harness will not revive. If your father died during the period he was under termination, that will not survive. You see, because there are other theories which will come in. First is that there can't be a reservation. The dying in harness scheme gives a time period for applying. So you could not have applied during that period because your father was not in service. So that is one part. The second part is that delay.
Delay means lordship, the after passing of the appellate authority lordship. So
But please show us any law where it has been settled that after termination, post facto, when you are reinstated in service, the status, you get the status of dying in harness. Because for, you see that the diastone merely gives you benefit of the pay and other retirement benefits. It does not revive that dying in harness. Because that day you are not in service. Status quo ante can't be paid. Now let us test this theory with an example. Now, a man is terminated in service on 1st of January 2024. Correct. He is entitled to medical reimbursement. On 2nd January 2024, he has some medical ailment, he goes to a doctor, gets treatment, 100 rupees is spent on medicine. Now his service is revived on 5th of January. Now can he come and say that, well, when I was terminated, on 2nd I had a medical ailment and therefore my medical reimbursement should be given to me? Because diastone, he is restored back to service. I don't think that dying to harness can be revived. No, sorry, we are dismissing it.
can it be on Monday lordship once?
No, we are not keeping it alive.
Monday lordship already one. Let me.
No. Once we hear it, after you hear the mind, then no, that can't be permitted. We could have taken an adjournment in the first go. But Mr. P.K. Das,
KD Sharma.
K.D. Sharma, the counsel for the petitioner, and Ms.
A. Talukdar.
A. Talukdar, and government advocate appearing for the respondent.
Respondent's lordship.
Next paragraph. The case of the petitioner is that his father, who was working as Havildar in 15th Assam Police within bracket IR, bracket close battalion, has suffered a disciplinary proceedings and he was removed from service by order dated 10/1/2014. Full stop. However, he died on 29/5/2015. Full stop. After the death of the father of the petitioner, his mother submitted
Sorry, lordship. Just
an
a minute.
appeal.
I made a mistake, lordship. There is not 5-4 lordship. 29/4/15 lordship.
29/4/15.
Okay,
Okay,
that-
the
that-
date of
that-
death is 29/4/15. After his death, his mother filed an appeal on 30/7/2019. Full stop. In connection with the said appeal, the appellate authority, i.e. the Deputy Inspector General of Police, within bracket AP, bracket close Assam, appellate authority, passed an order dated 10/11/2020 by setting aside the order of removal from service, and the deceased father of the petitioner was reinstated in service with effect from 30/12/2013 with all consequential benefits, all consequential financial benefits. Full stop. Thereafter, the next paragraph, thereafter the petitioner had submitted an application on 8/11/2021 for being appointed on compassionate ground. Full stop. His application was not considered. And thereafter the petitioner had approached this court by filing a writ petition. Big WBC 5821 of 2023. Agitating that his RTI reply was not received. Full stop. Thereafter, the petitioner had filed. What happened to the writ petition?
That has been withdrawn, Lordship. That is
Okay,
this.
so accordingly, the writ petition was withdrawn. Full stop. Next paragraph, the petitioner projects that that he made a fresh application on 12/10/2023 for appointment on compassionate ground. However, as his name was not considered, the present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph, heard the learned government advocate in the matter. Next paragraph. Under the facts as narrated above, it is seen that that on 29/4/2015, when the father of the petitioner had expired, his father was not in service. Full stop. Therefore, upon his service being posthumously restored, pursuant to order dated 10/11/2020, the father of the petitioner would only be entitled to the financial benefit in the considered opinion of the court, the allowing of all service benefits would not revive the status of the father of the petitioner to have died in harness on 29/4/2015. Next paragraph. Even if it is considered for the time being that the father of the petitioner had died in harness on 29/4/2015, yet under the relevant provisions of the office memorandum dated 1/6/2015 on compassionate appointment, an application for compassionate appointment is required to be made within a period of how much?
1 year.
1 year from the date of death. So admittedly, the petitioner did not pursue his earlier application for compassionate appointment made on 8/11/2021, and he has submitted a fresh application on 12/10/2023. Nonetheless, both the applications are beyond the prescribed period of 1 year. Stop. The next, in the cases of belated considerations of the applications for compassionate appointment, the Supreme Court of India in the case of State of West Bengal versus what is that? Divyabrata Tiwari. Get this citation there, AI 2023, they will know it, huh? The consideration for appointment on compassionate ground after considerable delay has been deprecated. Full stop. Therefore, the ground of delay, the application of the petitioner though remaining unattended, will disentitle the petitioner to consideration for appointment on compassionate ground. Next, therefore, on both the counts as indicated above, this writ petition fails of the same is dismissed.
Item 20.
Lordships.
Where is the order of the court dated 12/3/2024? Where is that?
My lord, page 72 and 75, my lord. The impugned advertisement to the interim protection is given, my lord.
No, I'm asking where is the order of the court?
72, page annexure J.
72.
Yes, this earlier writ petition. This writ petition was 5406. It says that another writ petition 5046, there is a protection and it is also same. And saying said order is page 75. No steps regarding the fill up the post is till the.
You see, I'm asking you a date, 12/3/2024. Where is that?
Oh, my lord, 24.
12/3/2024. If I have to read everything, I'll do it at my sweet time and then I'll.
Page number 101, Lordship.
101. There is a impugned, my lord. Not course order, I am sure.
101.
No, interim order dated 22/1/2024.
Yes, my lord, page
Where is that?
87.
Page
87.
87.
This clarification is made, the review protection of technician, not
Just a
action.
moment.
After this.
This, no, where is the previous order then?
My lord.
Where is the previous order? This is only a
Yes,
correction
but
order.
my lord, page 64, my lord.
64.
Yes. 72, my lord. Sorry, 72. 72 and 75. 72 is earlier similarly situated persons where protection is given. 75 and 72 is this our in our repetition earlier. Our is $75 is that repetition 54.
Just a moment. Where is the present appointment orders? Where are they?
My lord, 92.
92.
Yes, and 102. 92 this offer, my lord. 92. Well,
Yes, Mr. Chaudhary will have to state then.
They've already joined Lordship this person.
No, but it has to be stated. It can't be given effect to.
Difficulty is that Lordship, there was no specific order with regard to technician and senior technician. That is the reason why Lordship this.
Oh, no, you can't say that. Come to page 78.
Yes, Lordship, 78 I've seen Lordship. It's
Last two lines.
Yes.
The 3 lines. It is directed that no steps be taken to fill up the post of junior and senior assistant.
Yes.
Which are part of the aforesaid advertisement.
Exactly.
Now, this person you have appointed by page 92, what is the post?
Technician and senior technician.
in 87 it was cleared, my lord. As
Sir,
per
to
HOD.
depend post.
Where is the advertisement?
Advertisement is page 64. Annex
64.
Yes. Annexure I, 12 and 13. Column is the technician senior.
Just a moment.
Because the first writ petition was with regard to the senior assistant and junior assistant.
And that in that particular thing, that's why lordship on the last, this
No,
matter was taken up.
Just a moment. Just a moment.
Yes, there's a specific instruction I had obtained.
Just a
Yes.
moment. Page 64.
12 and
Column number 9, lordship. Senior technician.
Senior technician and junior technician is where?
Column
13.
number 12, junior is not there, technician and senior technician.
12 and 13.
And the
Yes.
first writ petition was with regard to the senior assistant and junior assistant. Column number 11 and column number 13.
This page 78 relates to senior assistant and junior
Junior
assistant.
assistant, lordship.
But not space.
Yes,
Page 87, kindly see, my lord, that
just a moment, we'll come to you. Now, you applied for which post, Mr. Barwa?
my lord, junior technician and junior technician. And I
Senior
have some
technician and technician.
technician, I have some impression that they are secretly going to appoint. That is
No,
why
just-
I
just a
educate
moment.
this and this made clear, my learned friend
Lo-
made clear that
lordship-
it also covered the protection also covered.
Lordship, kindly see in page number 73. When I had this supplied one communication dated 49/2023, where also it was specifically mentioned with regard to junior assistant and senior assistant.
73.
Page number 73, lordship, which would also protect the present petitioner. In this regard, he has placed on record a communication dated 49/2023. I'm having a copy where it has been specifically mentioned as per the instruction laid down by the interim order such and such of the Honorable Guwahati High Court Institute will not fill up the vacant position of junior assistant and senior assistant until the Honorable Guwahati High Court gives clearance. So it is very specific.
By that time, they have not made it distinguish that senior technician is not included, and after that, this honorable court, he has made clear, and that is why page 87, it is clear. After that, how can they now fill up this post? So they should come with the full information before the honorable court. Because this honorable court is impression that all the grade 3 and grade 4, our technician or assistant, these are state. That is the impression. That is why protection is given. Now they say that no, that
Mr. Barua,
my lord.
your earlier writ petition order
Yes, my lord.
starts at page 85, right? 2411. This is your writ petition. Is it?
Yes.
This is contempt. Your
Contempt is filed by.
no, your writ petition is page 72.
Yes, my lord.
Correct.
Yes, my lord.
In page 72,
Yes. Already protection is given, that is why, as per his submission, this court says that you are also protected as per order dated. Now he distinguished that
no, just
another earlier.
the present petitioners has his place on record communication intimate past complied with.
Yes, 504.
This is 59. This 14.9 does not cover your case.
My lord.
15.
Page 72, how does it protect you?
My lord, their submission says that because all are master worker grade 3 and grade 4. Some are technicians, some are general.
No, we are, you see, the stay order wherever I am reading is only in respect of
Junior assistant and
junior assistant and senior
Yes.
assistant.
Yes.
Now you are saying that the technical and
Technician and senior
technician and senior technicians are also covered.
Yes.
Where is that order?
That order, my lord, page 87. This honorable court, they have made clear before the honorable court. That is why we agitate this matter, whether this covered or not. Because by that time-
let me understand it first.
Yes, ma'am. Kindly see.
Page 87.
Yes, ma'am. We agitate this, raise this question. And he clarifies.
And this court says that no further order is required if the members of the present at any stage feel aggrieved. In any manner, it will be open for them to file an appropriate application.
Yes, technician also covered as his submission. His case impression, that is why honorable court says
How it
no,
is covered?
no apprehension.
Then it is not covered,
Now,
Lordship.
now it says
covered.
no.
It is not covered,
Both
Lordship. He
ways
did
he
not
can-
press for the stay order,
Mr.
Lordship.
Bhagat,
On the very first date, he did not press for the stay order. Thereafter, he was
We
saying
press
that
for the stay
it is
order.
covered. The
Stay order is-
presumption. Presumption is not a legal proposition, Lordship.
My lord, maybe my lord, I
It is
have
his
no knowledge
presumption.
that another writ is not pending. It is his case, his press that this will protect. Now he distinguished that.
No, I
no.
don't know because this is his submission is neither recorded here, giving an undertaking that it would protect the technical technician and the senior technician.
Yes.
Nor we can presume.
Lordship,
because-
this
But,
NIT
but when we agitate that whether it is protected or not, covered or not, he said it's covered. That is why apprehension is unfounded.
If it is covered, why the court will tell you that if they appoint, then you
Because
go and file a writ
He
petition.
gave assurance, my lord. Now he says that no, this is not.
Mr.
So-
Barwa, I am asking you a question. Have you understood the question?
Yes.
If the court says things that it is covered, why the court will say that you go and challenge it whenever the occasion arises?
That is why I challenge.
Now you challenge it. There is no stay operating.
My lord,
You will issue a notice only then. But Mr. M.C. Barwa and counsel for the petitioners. And Mr. S.P. Chaudhary, Leonard, counsel for
2, 3, 4, and 5, Lordship.
respondent numbers 2, 3,
4 and 5.
4, and 5. CGC who is appearing for one. Just give a name. Who was here? Just tell us a name.
Yes, yes. Yes, Lord. Yes, Lord.
Mr. P.S. Locker, Leonard, CGC appearing for respondent number 1.
Oh, yes, Lord.
Next para. The appointment of respondent number 6 to 45 in the post of technician and senior technician are under challenge in this petition filed under Article 226 of the Constitution of India.
in earlier repetition, my lord, 5406 also, my lord, that should be mentioned.
You want me to pass order in that petition also?
No, sir. Sorry. Sorry. ma'am.
You see, if you want the court to disturb you, I can merely say that they have not understood the matter, adjourn, take it up next week.
No, my lord, you are
Correct.
crossing.
You are having sufficient practice. Did I tell you, when we are moving a writ petition, in which writ petition you are asking an order? Should I ask that also to a lawyer?
No, I
Yeah?
just mentioned.
Don't push me to a corner
Yes,
when you invite sarcastic comments. Don't do it.
yes. Wait,
My idea is to be here, work with a smiling face, go home with a smiling face, and when the time comes to depart, if God willing, I have to depart with a smiling face.
my lord,
Don't push me to a corner where I change my character.
my lord, I am sorry.
I have to say construction, yeah. Issue notice, including notice on the prayer for interim relief. Returnable on, give a date after 5 weeks. Next one. Requisite extra copies of the writ petition is served on the learned CGC as well as the learned counsel for respondent numbers 2 to 5 within 2 days. Next paragraph, the petitioner shall take steps within 2 days for service of notice on respondent numbers 6 to 45 by registered post with AD.
Even one prayer is there, my lord.
Yes.
Through office, head office, we may distribute because individual address we cannot collect and cost title we have written. It is to be served through respond number 6 through the respond number 2 office, my lord. That may be liberty may be given. Individual we cannot collect. Then NIT will give everything from office they can collect. But that liberty may be given. Cost title I have wait. Leave give leave to serve notice through respond number 2 office. Otherwise, there will be difficulty, man. Page 7, 9, I have written posted.
No, but you are saying that they are they are working the office of respondent number 2.
Yes, through respond number 2, this liberty may be given. Others, individual address.
No,
Liberty is given to we.
They are working at respondent number 2
Office, yes.
office, right?
Yes.
Then serve it by post. You see,
Yes, respond to address, my lord. That line, my prayer may be.
because I can't ask a director of National Institute of Technology to find out people and serve notice.
Exactly. No,
Because if today I get a notice for one of my court staff, out of 1,200 staff, I will not be able to find him.
to that office, not director, my lord. To that through that office. That office.
How
Office
through
of the
that office?
director.
Directly he can send to the, in the name of the NIT.
And I think through
By
that office.
mentioning the name, he can send it by registered.
No, well, send it by post.
Yes, yes.
And
That
addition you can
address, my
do.
lord.
Substitute service you can do in addition.
Huh.
By registered post with AD at the office address of the respondent number 2.
Yes, ma'am.
Post of- Next paragraph, the learned counsel for the petitioner shall collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph, list on
28-6.
28/6/2024.
And this may I pray one. The other requisition, it should be come along with this listed.
No, not in motion.
After motion, yes.
You have not served notice to them.
Yes, my lord.
So neither this case will proceed nor the other case will proceed. You have passed such an order. After service is complete, you make an prayer. We'll
Yes,
we'll
yes,
consider
yes,
it.
ma'am. In that petition,
So
we have
this one, no
challenged this
objection.
technician.
The
object.
appointments made
Yes.
shall be subject to further order within bracket S. That will pass by this course.
Obligation.
Item 9.
Time being item 9.
If I'm appearing as a legal aid counsel in this matter,
Yes.
the challenges to an advertisement by Oil India Limited. So otherwise the issue is in a very narrow compass, Your Lordship.
I think here we'll have to issue a notice, Mr. Chaudhary.
Yes, in fact, my lord, what had happened, a matter is pending before division bench also. An advertisement of similar nature was issued by Numoligor Refinery Limited. The learned single judge did not grant any interim relief. So, my lord, a writ appeal has been filed, that is also pending. Yes, certainly it's an issue Lordship would like to examine. Yes, yes. We'll file our affidavit then.
And we only make an observation that any appointment made should be subject to further orders of the court. Heard Mr. K.P. Pathak, Learned Counsel, Legal Aid Counsel appearing for the petitioner. Also heard Mr. K. N. Chaudhary, Senior Counsel,
Or 1 and 2, my lord.
assisted by Mr. K. Kalita, Counsel for respond number 1 and 2.
3 to clear, right?
3 also, I think. 3 is the director.
Yes, yes, 3 also.
Three. And CGC, same name, Mr. P.S. Latter, and as well as Mr. P.S. Latter and CGC appearing for respond number 4. It is projected that the recruitment advertisement issued on
30/12/2023.
30/12/2023 purportedly gives a preference to persons residing at a particular place. And accordingly, the process is challenged in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. The learned senior counsel for the respondent numbers 1, 2, and 3 has submitted that as per instructions received by him, a similar issue is pending before the division bench of this court. Next paragraph. Be that as it may, issue notice returnable
Number
on give a date, fixed date after 5 weeks. 4 weeks. Returnable on so and so.
21/6.
Requisite extra copies of the writ petition be served on the learned CGC as well as to the learned instructing counsel for the respondent numbers 1, 2, and 3 within 2 days. Next paragraph. Any appointments made pursuant to advertisement dated 31/12/2023 shall be subject to further order within bracket S that may be passed in this writ petition.
My lord, that's not writ appeal, that's a writ petition before the DB. That is WPC number 1417 of 23. Not writ appeal, because they have challenged the rule. 1417 of 23.
23. Because we cannot refer the matter there, so
Yes.
I think you'll have to make.
No,
a
my
prayer-
lord, naturally, that is where the rule is challenged, as we have
No,
ruled.
no, that's okay. I'm just telling Mr. Pathak that perhaps this bench cannot say the division bench will take up.
Yes.
So it will be for you to make a prayer there.
Yes, yes, so that this can also be tagged there. Deeply.
Deeply obliged.
Item 21.
Here in this application, my lord, the accountant general, my lord, principal accountant general, my lord, is required to be implemented as a party. Since the, my lord, respondent number 2, my lord, the office of the respondent to send a, my lord, proposal of family
You
pension
want to impede whom?
of with 3, my lord,
3.
3, my lord. Opposite party 3, my lord. Accountant general, my lord, is the.
Okay.
One proposal is pending there, my lord, for family pension, but that is yet to be sanctioned, my lord.
Mr. Islam,
My lord.
you see, in the writ petition, in the order for which contempt is alleged,
Lordship.
there is no direction on the accountant general.
My lord, direction was given to respondent number 1 and 2, my lord, particularly.
Correct.
And
Now,
so far-
now please tell us, once you admit that there was no direction to the accountant general,
Lordship.
you tell us, have you given him a notice to comply with the order of the court?
My lord, so far during pendency of the present contempt petition, my lord, my learned friend appearing on behalf of the respondent 1 and 2 from the department side, submitted one letter, my lord. That letter is shown to have been issued to the, my lord, accountant general on 12th of January.
No, no, accountant general, you see, proposals are, every proposal go to the accountant general to release.
Lordship.
Correct.
My lord.
So therefore,
On the previous order, my
For-
lord, of this court, my lord,
I'm not asking you that.
Lordship.
My question to you is that when you allege that the accountant general is in contempt,
My lord.
please tell me, have you given him a notice that he is in contempt? Have you brought the order of the court to his notice? If not, there cannot be a contempt.
No notice, no notice was served, but on the previous order, my
You
lord.
can't presume.
Lordship.
If you can show us any authority by which one can presume that one is in contempt, I'll be very happy.
My lord. Lordship, what the contempt law said, my lord, what is in my submission, my lord, any authority or any person, my lord, who actually ultimately the order passed by this court, directly or indirectly, my lord, that authority is, my lord, validity, my lord. That or
I can't subscribe to that. If you give notice, it is okay, otherwise we close it. You have to put him to notice.
then, my lord, I may be take penny, and in the meantime, my lord,
That's
I'll-
okay. Heard Mr. M.A. Islam and counsel for the petitioner. This interlocutory application has been filed for impleading the opposite party number 3 as the respondent number 3 in the connected contempt petition. First off, as there is nothing on record to show that the opposite party number 3 was put to notice to comply with the orders of the court, comma, on a query made by the court, comma, the learned counsel for the petitioner, public applicants, seeks some time to put the opposite party number 3 to notice and bring it on record by filing an additional affidavit. So there is allowed, matter stand deferred today. List as and when the additional affidavit is filed.
Lordship, fix it on the 1st or 2nd of June, my lord. By that time, or
Yeah, I've said whenever you file it, it will come.
Lordship,
You make a mention, we'll call it.
my lord.
So you'll have to file something on record.
Immediately, I'll-
We'll take a break and come back.
Lordship. All right, my lord.
Upgraded item 44 with 45.
It's an application is preferred, my lord, since weekly pledge.
Who's paying for APDCL?
It has been informed to them that we have mentioned the matter before lunch also, my lords, and they said that they will be appearing the matter.
SC APDCL. Just wait for some time.
Deeply obliged, my lords.
We'll call it again. Oh.
Much obliged.
Item 23 for admission.
Case of compassionate appointment, my lord. And on the last occasion,
Here the DLC recommended the case, but the SLC has not considered the matter, holding that it is not within the 5% quota. But
But there is another reason, 2016. You
And that-
closed the court after 6 years. We are taking adverse view of the delay and we are dismissing the repetitions of this nature. The SLC minutes are of 2018.
on 16 who died.
He died on 28/5/16. And the SLC was 31/12/2018. The challenge is made in 2022.
DLC recommended earlier. On 12/16. And I remember, Milord, may not be in this matter. I approached the Honorable Court also in some matters where after DLC recommendation, SLC was not sitting. And after direction of the Honorable Court only, DLC was held, SLC was held. Not in this case, I suppose. Not in this case, but in 2 other cases, Milord. That was the position.
But Mr. Salia, even on merit, you see, there may be vacancies available, 16 vacant posts you are saying.
My lord, yes.
Correct. But the question is that from the entire cadre, if 5% is already filled up with the compassionate appointments, we can't order any further appointment.
No, we have stated.
Actually, that is not been shown to be incorrect. Number of vacancies does not mean that that there are
Now under
quota.
the new OM, Milord, the compassionate appointments shall be made only in grade 3 and grade 4 posts against vacancies under the direct recruitment quota. Whole quota in the year, not for vacant positions.
2015.
Yes, that I have an next, Milord.
2016.
That was of 2015.
Page
I am giving. In the IA 1433, Milord, there at page 7, 1st June 2015.
Yes.
At page 12, internal clause 10. Previously was 5% of the vacancies.
And I mean, it may be up due to COVID also, because from 19 and 20. Right.
Mr. Salia, please come to the same OM at page 14. You see clause 14, it says compassionate appointments can be made up to limited of 5% of the cadre strength.
That is below, that
And-
percent is there.
No, that's okay.
Hmm.
And the next you are showing us is that principle. That 5% is only from the direct recruitment. That means
Yes.
that means
Rank
it
of cadre,
cannot eat up
which one?
the promotional quota. Any grade 3 or grade 4 has to have fulfilled two criteria amongst others. First, it should be within 5%. And second is that it can only be from direct recruitment.
Necessarily,
Therefore,
necessarily.
promotional quota is not
Not
excluded.
any other
So
quota.
therefore, even if there are 14 vacancies, you have to show us from the cadre strength that these 5% are available. You see, this finding of the SLC or the SLC must be shown to be incorrect.
That is page 40, not there, stated only. This is page 18, serial number 40.
Page 18 of the writ petition.
My lord. SLC finding.
Not within 5% quota.
Hmm.
So how this is incorrect?
Because none were selected.
No, but what is wrong in that? If it is not within the 5% quota, no one will be selected. But so far as respond number 4 is concerned,
Yes.
you have to tell us that even that part. In your affidavit, you don't say anything. Who is responsible for?
Is the
Deputy Secretary to comment on.
Secretary PWD.
Yes, I'm a
Deputy Secretary, you have to
We
tell
don't
us
give
how many vacancies are there, or what is the 5%
Not
quota?
explained, not explained. And it states lordship 5% of the vacancies reserved for compassionate appointment is already.
Tell us when somebody is challenging it. The PWD must tell us that the cadre strength is so much and these are men in position.
Also, that I can place that. Now also I can place that. Also, this is the particular cadre.
Huh.
This many persons are already working who are appointed against compassionate.
We give you 2 weeks time, or you need more?
Not to be going to grant me 3 weeks for it.
3 weeks.
I'm from Kolia.
Okay. Mr. DP Salia, Leonard, Senior Counsel. Assisted by Ms. M. Roy, Counsel for the petitioner. also had Mr.
CS Hazarika, Your Lordship.
C.S. Hazarika, learned government advocate appearing for respondent numbers
1, 2, and 5.
1, 2, and 5. And Mr. P. Nayak, and then standing counsel for the PWD representing respondent number 4 and 6.
3, 4, and 6.
3, 4, and 6. Next, brother, the respondent number 4 in his affidavit in opposition has not specified the cadre strength and man in position within 5% quota for compassionate appointment. Therefore, the respondent number 4 is directed to provide instructions to the learned standing counsel for PWD regarding the cadre strength of junior assistant grade 3 in the office of the executive engineer PWD, Koliabor Rural Road Division, and the man in position who are appointed within 5% quota earmarked for compassionate appointment. Next, the respondent number 4 shall take note that the information furnished would be made a part of record, and therefore the responsibility will be on the responsibility of providing correct information shall be on the person providing the information. Full stop. Next,
Not even fix it.
alternatively, the respondent number 4 may also file an affidavit
Lordship.
in that regard. Next, list on after 3 weeks, give a date. After counting, make it after counting so that officers will be free. Counting is on 4th. Today you told me. So we're making it 10 June then. 10 June.
Lordship.
10 June.
44 with 45.
Alex. That's my learned friend, sorry.
Yes, you have examined it.
My lords,
Then suggest a name within the panel.
if I may just only point out, subject to what my lordship holds, ma'am, only on a point of law. Now, the objection they're raising is qua section 12(5). That is a challenge before the arbitrator.
No, you see, there's two ways to look at it. Number one, last time when you were appointing, you made an objection.
Yes, my lords.
Correct.
I'm only on the
Now,
point of law.
now, when we appoint, he says that the same clause applies for this arbitrator also.
Yes. Now,
Because if it is within the meaning of de jure,
Right.
then
Yes.
you'll have to either from the APDCL, you have to give an undertaking that you will not raise that issue.
parties appear before, they'll have to submit to the jurisdiction. ma'am.
No. Submission of jurisdiction, if there is a legal bar, to override the legal bar, there will be an admission by the parties
Yes, ma'am.
that they subject themselves to that and they will not take that plea.
That question of, my lords, whether there's a legal bar, because the objection or the application revolves around section 12. Now, section 12 per se, my lords, is a challenge to the arbitrator.
No, you see,
And the procedure
last time,
enshrined for
I-
that challenge is
I
under
won't
section
remember the
20.
details, but last time he pointed out, he referred to two judgments.
Yes, my lords.
Saying that this was a consideration
Yes, my lords.
for interfering with the arbitral award.
Yes, my lords. And even though.
Now,
my lords,
he's apprehending that tomorrow he subjects himself to the arbitration
Well,
proceeding.
my lords may record my submission. I'll not be objecting to that. jurisdiction or the issue as far as the arbitrator goes.
Malas, my respectful submission is this issue is also been settled by the Delhi High Court, Malas. Malas, the Delhi High Court has gone back and said that even if this objection is not taken at any point of time, and it is taken for the first time in 34, this objection will stand by itself as a standalone, Malas. That authority I have given to this honorable court, Malas, on the last date of hearing. That is Mansingh Authority, Malas. Yeah. Man Industries.
Man Industries.
Man Industries.
Yeah,
Malas would see
further
the relevant
paragraph.
portion would be para 23, 24, Malas. 24, 25 Malas at page, internal page 10 at the bottom, Malas.
25.
20,
In-
para 25
In
to
line engineering,
line engineering, Malas, the Supreme Court held that even without an amendment in the petition, the plea of lack of jurisdiction of the arbitrator can be raised, even though no such objection was raised under section 16 of the Act. In so and so, the court held that if there is an inherent lack of jurisdiction by the arbitrator, the plea can be taken up at any stage and also in collateral proceedings. Such plea can be taken even where the parties has consented for the appointment, Malas. So unless I can't even go back and consent about the appointment because tomorrow, even if he has given a consent, he can withdraw it at any time.
What I'm dealing with is not section 16. Section 16 is with regard to jurisdiction under the doctrine of competence. Here we are dealing with 12 and schedule 7. Schedule 7 for a moment, my lord.
yes.
Schedule 7, my lords, the top of the, it reads, my lord, see section 12.5. Now 12.5 and the issue that they're raising, my lord, relationship of the arbitrator to the dispute. 15 or 16 of the 7 schedule, my lords. The arbitrator has previous involvement in the case. Arbitrator has given legal advice or provided an expert opinion on the dispute. Now, for this objection respectfully to be taken, it is not a objection that they have to take under 16. This is an objection they'll have to take under 13.
No, 16 is about
If I may just
jurisdiction.
submit, my lords. 16 is about jurisdiction. I'm not
Yes.
denying that, my lord. Now, if there is a apprehension about an arbitrator not being able to act properly or in accordance with the contractual obligations of the arbitration clause, that dispute or that objection they'll have to take under 13, my lords. And this respectfully, my lords, is a section 11 proceeding.
Well, a similar issue was being dealt
Yeah,
with.
just,
Yes,
just. He has also given that the judgment of
Gujarat
GRE
High Court.
infra.
Yes, ma'am.
So
Gujarat
that-
High Court, Malas, I've given it to, well, I'll just show it to my
So
learned friend
I'll leave it
also.
to my lordship.
Malas-
Only a legal submission that I have to
Because
make.
Once the Supreme Court has interfered.
Yes, Malas.
Now, because Malas in
expressed that
11, bringing in grounds of challenge under 12 and the schedule there and
Just
there
to
is a
count-
procedure under 13 and 14.
But
Malas,
just to
of a
counter my
challenge
learned
before
friend
that
submission, just to
arbitrator.
counter my learned friend submission, Malas, we are still at the stage of 11-8. Malas, where the proposal has been given of appointment of an arbitrator and a recommendation has to be sent to the proposed arbitrator for his 12-5 declaration. So we have not yet, the constitution of the tribunal has not yet taken place. Malas, we are still in the 11-6 and we are still within the section of 11. And 11-8 Malas is the one which is still going as a process as of now, Malas, which has been stayed by the last order. The second, my learned friend contention to go back and raise it in the tribunal. Malas, even if I go back and raise it in the tribunal, and even if I go back and give a consent, Malas, even if the tribunal goes back and says in the jurisdiction under section 16, taking a cognizance of the fact that the objection is taken, but I set aside the objection, Malas, even then the Supreme Court says that you can take it as later as in the 34 also, and set aside the entire orbital ward. So Malas, my apprehension and my anxiety, Malas, I do entire exercise. And Malas, on this technical ground, Malas, it gets away tomorrow. The entire
you have very
exercise will frustrate Malas.
You have a very ground. But Mr. P. Button and counsel for the applicant, as well as Mr. B. Chaudhary Leonard, counsel for the opposite parties,
For the opposite party number 1, Malas,
opposite party number 1.
the society. Malas,
Ah.
Malas may record Mr. KP Pathak's name for
And
response.
Mr. KP Pathak, Leonard,
For the
counsel
forest
for opposite party number 2. Next, para. This court by an order dated 22/4/2024 had proposed the name of a former judge of this court to be appointed as a sole arbitrator to arbitrate the dispute between the applicant and the opposite parties. And upon proposing of such name, a notice was made returnable for being issued on the learned proposed arbitrator to make disclosure as per the requirement of subsection 8 of section 11 of the Arbitration and Conciliation Act, 1996. Usman. The applicant, who is the petitioner in the connected arbitration petition, next one. Where is the where is that interim order of the court in the arbitration proceeding?
That's at annexure 4. Annexure 4 at page 41.
Page?
41, Malaj. Page 41 of the paper book, Malaj. Page 41, annexure 4, Malaj, is the order of the
Okay.
predecessor case.
By referring to order dated 10/11/2023, passed in the connected arbitration proceeding, arbitration basic petition 17 of 2023. It is submitted that the proposed the honorable proposed arbitrator
Is at page
had
8 and page number 9.
applied. No, what was the
Is at page number 9 of my paper, application at para 8.
9?
Yes, please. Page number 9, para 8, so and so, while sitting as a judge of so and so, had adjudicated and heard at length the aforementioned arbitration petitions and had expressed its opinion as to the construction and interpretation of the clauses. Page 9 and para 8.
That's what I'm referring to.
Read liberal.
What was as a judge of this court had heard the said arbitration petition 17 or 2023 on 10/11/2023 and had expressed an opinion with regard to the construction and interpretation of the clauses of the contract. On the clauses 20.2 and 20.3 of the contract agreement dated 4/5/2021. First off, in this regard, next paragraph, in this regard, by referring to the order dated 8/4/2024, passed by the Supreme Court of India in the petition for special leave to appeal, within bracket C, number 27360 of 2023, had referred to the objection to the arbitrator nominated on the ground that he had previously acted as a judge at the interim stage in a matter arising between the same parties pertaining to the same arbitration. And on the said ground, the order of the impugn order of the Gujarat High Court dated 10/11/2023 was set aside. By referring to the decision of the Delhi High Court dated 1/6/2023, in the proceedings of OMP within bracket CUMM bracket close 252 of 2018 and IA 13103 of the 2022, in the case of MAN Industry, MAN Industries, in bracket India, bracket close limited versus Indian Oil Corporation Limited. Has taken the following view, paragraph 25 to
25, 26, 27.
26, 27.
Yes, my lord.
26, 27. Which is quoted below. Next, accordingly, comment is something that although the appointment of the honorable proposed arbitrator is not objected to at this stage by both the parties, yet the arbitral award could be susceptible to be interfered with on the ground that the arbitrator so appointed could be held to be a held to be more constant de jure,
Ineligible, my lord.
rendering him ineligible to arbitrate the dispute.
Deeply obliged, my lord.
Next paragraph. Per contra, the learned counsel for the opposite parties, opposite party number 1 has submitted that the lead sought to be taken by the applicant now can otherwise be raised in the manner as prescribed
Under
under section 16.
13 months.
16 also no.
16.
Or,
16
13. Okay, 13. Which subsection?
13 lays down the challenge procedure, my lords.
No, but which section? Which subsection?
13.2.
13.2.
my lords. On the grounds mentioned in section 12, my lords.
13.2 on the grounds mentioned in subsection 3 of section 12. Which permits an arbitrator to be challenged if circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Next paragraph. Something that the Supreme Court judgment, they report the judgment. This is Supreme Court judgment. Next paragraph. It is noted from the order of the order dated 8/4/2024 passed by the Supreme Court of India in the case of JRE Infra Private Limited, in bracket Supra, that having acted as a judge at the interim stage, the same arbitration proceeding had led to disqualification of the had led to setting aside an interference with the order dated 10/11/2023 by which petition under section 12 within bracket 5 of the Arbitration and Conciliation Act was rejected. Full stop. The judgment of the Delhi High Court in the case of Man Industries within bracket India bracket was limited in bracket Supra has interpreted the issue in light of the provisions of section 34 of the Arbitration and Conciliation Act, as well as the provision of section 12 within bracket 5 of the said act, to hold that even if the parties consent for an appointment and obligor take no objection during the entire proceedings, yet such waiver would not come in the way to raise the issue of lack of inherent lack of jurisdiction of an arbitrator at any stage of the arbitration proceedings or even in a collateral proceedings. Next, therefore, comma. Despite the objection raised by the learned counsel for the opposite part number 1, the court does not find any reason to not modify the order and prevail upon the parties to arbitrate the matter to the proposed arbitrator only. Because of the fact that even at a subsequent stage, the appointment can still be put to question. Next, therefore, comma. The court is inclined to modify the order dated 22/4/2024, passed in arbitration proceeding 17 of 2023 and arbitration proceeding 18 of 2023, insofar as the name of the proposed arbitrator is concerned. Full stop. Accordingly, in respect of the name proposed in paragraph 2023 of the order dated 22/4/2024, arbitration proceedings 17 of 2023, and separate order dated 2022/4/2024 in arbitration proceeding 18 of 2023, thereby proposing to nominate and appoint Shri Achintra Malla Pujar Barua, a former judge of this court, as sole arbitrator, and substitute the proposed arbitrator
Malas, I have proposed two names to my learned friend, Malas. He can choose any of them, Malas. One is Mr. Manojit Bhuyan, Mr. Malas, and Mr.
No,
P.
he
K.
also
Tekar.
has the same thing because he's he's in
Malas,
the
then
government.
Malas can appoint any retired judge from the Supreme Court, Malas. Justice.
We propose to appoint
Some Supreme Court retired
Justice
judge.
B.D. Agarwal.
ठीक है Malas.
Justice Vasudev Agarwal, a former judge of this court. The residence of, you'll have to find out, residence of so-and-so as the sole arbitrator to arbitrate the dispute between the applicant and the respondents, applicant oblique petitioner and the respondent of the opposite party oblique respondents. Next para. Consequential orders for issuance of notices shall be passed in the connected arbitration proceedings. Arbitration proceeding, and in the arbitration proceeding, right? But so and so. Next, in view of the order passed today in IS Civil 1228 of 2024. There are separate applications.
Yes, Malas.
In
There's
both the
separate
cases.
application in both the applications. Both the cases.
So one will be in 17, it is 1228. And in 18, it is 1229. Separate orders. You the past order passed today in IS Civil so and so. The directions contained in paragraph 23 stands modified. First of the modified paragraph 23 will now read as follows. Here only the name will change. Paragraph 23. Next paragraph. Consequently, letter notice returnable on after date after 5 weeks. Returnable on so and so be issued to the learned proposed arbitrator.
So very obliging.
To make disclosure as per the requirement of subsection 8 of section 11 of the Arbitration and Conciliation Act, 1996. Next paragraph. The petitioner shall take appropriate steps within 3 working days for issuance of notice on the learned proposed arbitrator, together with a certificate copy of the order dated 22/4/2024, as well as the order passed today. Next list on
17th of July.
17th. I'm so very obliged, Malas. It's an honor to appear, Malas. Deeply obliged, Malas, for the patient hearing. Deeply obliged, Malas. Deeply.
Item 24 for admission.
Yes, who's for the respondents? You are not filed affidavit?
No, Lordship, we have received an instruction, but Lordship, our stand, the matter is that Lordship,
Oral stand will not do. We'll allow the writ petition then. No oral stand.
Lordship will file the affidavit.
None of been call for the petitioner. Mr. D. Bhattacharya and government advocate is present. Huh?
AG. Advocate, attorney, I mean, sorry.
For respondent number
Respondent number, 3, Milord.
3 is present. Next, Mr.
U Sharma,
U Sharma, appearing on behalf of
Mr. S Datta.
Learned Counsel appearing on behalf of Mr. S. Datta, standing counsel for PNRD department. Submits that he has received instructions and the PNRD department will be filing an affidavit in opposition within 2 weeks.
Lordship, 3 weeks maybe that.
3
We have to acquire up-to-date instruction, Lordship.
Huh?
We have to ascertain whether the DP has been completed or not. Because Lordship, the pay fixation that he is claiming, that has to be, the department is not fixing his pay because the DP is continuing. And that was their stand in 2022. And right now, as of now, whether the DP has been concluded or not, that has
No,
to be
that we can give, get you tomorrow. We'll ask the officers to be present personally. For that, we can't wait from 2022 till 2024 to give you instructions.
a reasonable time.
You'll
Lordship,
get it.
will be given.
You file an affidavit. Those instructions will not come unless you order personal appearance. We'll ask you to vacate the table where you are sitting, and we'll ask the officers to work here.
Okay.
Just tell us the time. You want it by tomorrow, 2 o'clock?
No, no, 2
No,
weeks we
okay.
will file your affidavit, Lordship.
Okay. So to file affidavit in opposition to the matter. List one, give a date after 3 weeks.
12th of June.
Deeply obliged.
Item 26.
This is regarding a disciplinary proceeding culminating in the termination of service of the petitioner. It could take some time, and perhaps on a hearing day if it is fixed up for disposal. The records, my lord, in original perhaps would be necessary because I have alleged manipulation of the proceedings also.
You don't pass any order to call for the records.
Not as of yet. That has to be called for.
Where is the allegation of manipulation records?
My lord, we'll see.
If it is there, I missed it. Where is that?
Lordship will find that even before, can we have this page, page 42 for a moment, madam? Page 42 of
Because
42 of my
from your petition, I gather
madam.
that you had called for the records, and by the time you got it, 2 witnesses were examined.
No, I'm not on that. What has happened is, even before I got a copy of the memorandum of charge, they had already formulated letters recording my plea of guilt, asked me to make a backdated signature. I refused. It is then that they started the inquiry proceeding again, calling back the witnesses they had already taken. That is one of the allegations. That is why I
Where
was
is that?
quite.
I missed it.
My lordship will have page 42 for a moment.
No, in the pleadings, where is that?
In the pleadings, yes.
Within page 10, you are only saying that you were given copies. By such time, 2
Yes,
evidence were already
Lordship will
recorded. But that there was a manipulation, then those I could not
Lordship
find
will
out.
have page 8.
8. Yes.
Para 10. That on 25/7/2021, the inquiry officer directed the petitioner to be present before him and gave a petitioner a copy of a communication dated 19/7, which had recorded that the petitioner was required to be present before him on 21/7/2021 to plead guilty or not. He also gave the petitioner a document dated 21/7/2021, which purportedly recorded the preliminary hearing of the petitioner. There was also another document which showed that the recording of the statement of Sri Sunil Kumar Rabha allegedly recorded on 23/7/2021. The inquiry officer therefore told the petitioner to put backdated signature on the said papers to show that they were received by the petitioners on 19/7/21, 21/7/21, and 23/7/21 respectively. The petitioner vehemently refused to put any backdated signatures on such papers. The inquiry officer is very angry with the petitioner for having refused to put backdated signatures on such papers. Para 11. That on 26/7/21, the inquiry officer gave the petitioner a copy of an order
order date 25/7/21, which was almost a replica of the earlier letter dated 19/7/21. However, the present letter of the petitioner was required to appear before him on 27/7 for preliminary hearing. On 26/7/2021, by written communication, the petitioner had requested for certain documents. Now, this allegation that they had pre-prepared my plea of guilty and the evidence of Sunil Kumar Rabha, even prior to asking me whether I pleaded guilty or not. That document, the copy which I had, the translated copy I have given, that is at Lordship will find it page 42. I have the carbon copies that they had given me, that I will produce, but they have to produce their own inquiry record also to show whether such letters are there in the record or whether it has been manipulated, because it contains the signature of the inquiry officer in my copy. Page 42, Lordship will see answer to question number 6. Do you plead guilty to the charges? Answer: I plead guilty to the charges leveled upon me. This is signed on 21/7/2021. Lordship will find down below. Page 42. This is a type copy, translated. Question number 6. Do you plead guilty to the charges leveled against you in the order dated so and so? Answer: I plead guilty to the charges leveled against me. It is signed by the presenting officer on 21st, unsigned by the accused, and signed by the presenting officer on 21/7/2021. Then on the next page, Lordship will find Sunil Rabha gives his evidence.
Okay.
These records, whether they are in that inquiry, and they say, because Pamula Kishore, the inquiry officer, has been made a party by name. I have alleged malafide. There is no affidavit from her. And the affidavit in opposition has been filed on behalf of all the respondents by an official.
Mr. Mazumdar, counsel for the petitioner. So by referring to the statement made in paragraph 10 and 11 of the petition, it is clear that the records of the disciplinary proceedings against the petitioner we called for. Next paragraph. The learned CEC shall open the original records of the disciplinary proceedings initiated against the petitioner. Full stop. Next paragraph. The learned CEC prays for how much time?
Lordship, it will come from Chhattisgarh, Lordship, so sometime maybe.
Prays for and granted 4 weeks time to procure the records. The learned CEC is also permitted to send a downloaded copy of this order to the concerned authorities to obtain the records. List. After 4 weeks, give a date. 4 weeks, make it 5 weeks, give a date.
17.
Obligation.
I can take up only 2 other matters, other will be rolled over. Item 28.
28.
May I please the lordship? My lord, in this case, both parties are now agree, my lord, to let them have taken on 29, my lord. Senior has already late. 29.
The positive time matter could not be taken up. Only both sides are represented. List on 29, 5/2024.
Interim date.
Okay, interim order passed today, stands extended to the next date of listing.
29 is.
I'm like.
29.
Lordship, here matter related to selection and appointment of assistant professor against the Lordship PWD quota. Lordship, she has been selected for the post of assistant professor Assamese Lordship in Duliajan College.
Please for help. Yes, Mr. Opunya.
Pleadings complete, Lordship.
Lordship, pleadings are complete, Lordship, in this matter, Lordship.
Any hearing?
The only point involved here is for for a review medical board
Yes,
to
Lordship.
examine the petitioner.
Yes, Lordship.
Any serious objection to it?
No, Lordship, they have admitted, Lordship, already admitted that her disability may be increased.
Lordship, there are various matters wherein after appointment, Lordship, the concerned department has asked us to re-verify, to reassess. We have reassessed and we have found that they are not in the 40% category, Lordship. They are much below than that. So we have given them the reports, Lordship. Now they are challenging the report, Lordship.
Or is it?
Yes, Lordship. And privately, Lordship, they have gone to the AIMS and they have done
Not-
some,
Not
Lordship.
privately, Lordship.
There is no such
The-
order that we have asked
Lordship,
them to go to the
district-
higher.
Lordship, District Medical Board has referred, Lordship pays, it is in pays, Lordship,
Similar matters are
Yeah.
disposed of.
83, Lordship, 95, Lordship, of our affidavit, additional affidavit,
Page?
page 95, Lordship. Of our additional affidavit. For review of her disability status, it was sent back to the District Medical Board who issued the Lordship disability certificate. This is issued
We'll have to fix some other date for hearing.
Yes, Lordship.
on Tuesday, Lordship.
Both sides are represented. So positive time matter could not be taken up today. List on when?
Tuesday, Lordship, next Tuesday.
Lordship, can it be, Lordship, on 28th, Lordship?
So that may be given. Lordship.
5/2024.
Wait, please.
Highly.
Item number 39, the government has some, it can be 27/5, Your Lordship. Item number 39, Your Lordship. The government has some urgency, Your Lordship, so can it be fixed on 27/5, Your Lordship?
No, not on 27/5. There's a division bench that day. Will the court master fix a date?
Some early date, Your Lordship, then I'll
28th?
28.
28. Due to positive time matter could not be taken up today. The learned government advocate expresses urgency in the matter. List on 28/5/2024.
There is an interim order that to be completed in next.
In this case?
In 39 months.
39, okay. Interim order extended.
Lordship, item number 34, one date may be given.
The court master will take a call.